Green is not. ಇನ್ನು ಕೊಡ್ತಾರೆ ಮೆಮೋಸ್ ಸಬ್ಮಿಷನ್ ಮೆಮೋಸ್ ಅದು ಫಸ್ಟ್ ಕಾರ್ನರ್ ಅಲ್ಲಿ ಡೇಟ್ ಬರ್ಕೊಂಡು ಬೇಗ ಇನ್ನು ವೆಡ್ನೆಸ್ಡೇ ನೋಡ್ಕೊಂಡು ಡೇಟ್ ಬರುತ್ತೆ ಆಮೇಲೆ
The trial for the matter is tomorrow, my lords. The matter was already settled before the mediation, my lords. She has not complied with the mediation report. The wife has filed one more J&W case before the family court, my lords. She has not shown us the minor child from 6 months. And that she has filed one more J&W case with the same circumstances, my lords. The matter is tomorrow, my lords. Lordship will take the matter tomorrow. For tomorrow, my lords.
My lords, warrant is issued in trial court, my lords. We have challenged the order, my lords, for maintenance. Notice was issued, my lords. They have filed wakalat also, my lords. My lords may kindly take it up tomorrow.
Yeah.
Yeah.
Lords, in this case, there was a visitation raised by this
Use the mic.
In this case, my lords, there is a visitation rights by this honorable court. So they are not, respondents are not showing the child. So the petitioner matter may be posted on 16th.
Date also you will give.
No, sorry.
Tomorrow is, yes.
2016 MC, my lord. Because 2016 MC petition has filed in the trial court, my lord. Just because of this writ petition is pending, the husband is dragging the case in the trial court, my lords.
Which year is the petition?
23, my
Which
lord.
year?
23.
Okay.
Tomorrow.
In this case, interim order was granted, subject to depositing arrears of maintenance, which was 4 lakhs. Initially, within the time granted by this court, we have deposited 2 lakhs. After that, other remaining amount of rupees 2 lakhs also deposited. But in spite of that, the trial court insisting to deposit the entire amount. Earlier to that, we have filed it's tomorrow.
Each wise mentioning.
Serial number 40. Serial number 48, permitted
They'll call.
withdrawal.
Number wise they'll call,
Page
then you
wise
can.
adjournment.
Yes.
Page wise adjournment, page 1, serial number 1 and 2, page 2, serial number 3 to 7, page number 3, serial number 8 to 11.
Serial number 8, my lord. The parties have got along together. They are not responding. I just check for time, my lord.
Your instructions, sir? No, they have settled the disputes.
Yes, my lord.
They're residing
the court,
together.
they had informed us that they are settling the dispute. Now they are not responding to the calls in the last 2 months. I'll verify once again and find out.
Notice is not served till now. First of all, pay process for the
I'll complete the process.
needful shall be done within a week, or
Yes,
else the petition stands dismissed without further notice. Next.
Page number 4, serial number 12 to 12, 13. Serial number 13, my lordship. I pray for 1 week time for filing the
Office
memo.
objections, they're all the same. Don't call the office objections, call the next matters. Interlocutory applications from.
Legal aid is, it is referred to through legal aid authority, my lordship. That's
Oh, that party in person
party in
case.
person. my lordship.
You got all the papers?
No, and today I received the.
This is the matter. According to your, what is the urgency when she wants?
When you, 1 week, my lordship.
Week is
1 week.
Monday, next Monday.
20 months.
Yes, straight away call from interlocutory.
Hearing on interlocutory applications, page number 7, serial number 19.
My lordship, serial number 17, my lordship, I am withdrawing the petition.
Take that. The memo is filed seeking to withdraw this petition, stated that the interim custody of the child during the summer vacation is granted by the court, and as the petition has become infructuous, accordingly dismissed as withdrawn. Yes,
Lordship, serial number 14, my lordship. Sorry, my lordships.
14.
My lordships, I'll file acknowledgement to that effect, my lordships. I have not filed the acknowledgement.
If
to-
everybody starts mentioning the orders matters
Page
in
number.
it's difficult. That's why I asked her to call from interlocutor. Yes.
Number 8, serial number 20 to 24.
Serial number 22, my lordship.
Have you informed the, no notice also in a 24 matter? Why we should adjourn the matters? I'm not able to understand. Every time this is happening, matters are listed even for admission of 2024 matter. List this matter finally tomorrow, no further adjournments.
My lord, serial number 23, my lord.
Yes.
Some talk between the parties is going on regarding the settlement. This may kindly be taken during the last week of August, my lord.
Have you informed the other side?
Yes, my lord. I have
Submitted
informed.
also going on, and the counsel for the petitioner had already informed to the learned counsel for the respondent. List this matter on 29th of August.
My lord, serial number 21, adjournment 21, my lord. 1 week time.
No,
Let's see.
none of these matters will be adjourned, right from 21 to all this till 35. Yes, anything from 36?
Serial number 36 to 42. Page number 10.
37, serial number 37, the avoid mediation report is there. Short accommodation.
It is there.
Along with mediation.
Mediation report is there.
No, not coming soon. Not settled in the matter. It is still pending. Mediation pending is something.
Along with mediation report.
It is mediation report there or not? What does it mean?
Mediation.
Mediation report is here.
I don't know.
Yes, if it is not settled, it will come back to the court. You
Yes.
have to argue. Yes, next.
Serial number 38.
Yes.
ಕನ್ನಡದಲ್ಲಿ ಇದೆ ಸ್ವಲ್ಪ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿ kindly have done after 2 weeks.
Why the impugned order is in Kannada?
ಕನ್ನಡ ಇದೆ.
It is submitted that the impugned order is in Kannada. List the matter on 30th of July. By the time the translated copy shall be filed. Yes.
Okay.
Page number 11. Serial number 43 to 51.
Serial number 43, my lord. Honorable Family Court allowed the main petition, my lord. On 13 to 25.
It is submitted to the main MC. It is MC.
Serial number 48.
Criminal revision petition.
Criminal
Petition, my lord.
miscellaneous.
Criminal miscellaneous, my lord. 454 of 23.
Disposed of by the court, and a memo is filed seeking to withdraw. Memo has been filed.
No, my lord. No,
It is submitted that the petition has become infectious, dismissed.
Published.
45, for the petitioner, my lords. I'm seeking a week's time to seek instruction to withdraw this petition, my lords. Week's time, my lords. I'll seek instruction from my client to withdraw this petition. Because the final
Any interim
order
order
may.
is there in this? No interim
No
order.
interim order.
The counsel
No
for the
interim.
petition submits that the petitioner wants to withdraw the petition for filing the necessary application, seeks a week's time accordingly. Yes, list this matter on 22nd.
Serial number 50, my lords, 50.
Yes.
For respondent.
Yes, 50.
Weeks accommodation. Next week.
Why?
So for fine, we are trying for a settlement. We just spoke to each other. Okay.
It is submitted with the likelihood of settlement
2 weeks make
matter on 24th.
Serial number 49, your honor. Respondent on record has become DJ, your honor. She has filed NOC declared to another advocate, so for a 1 week time.
You're making request on behalf of respondent.
Yes, madam.
At the request of, have you informed the petitioner counsel?
No, we have not.
Wait till the matter is called.
Serial number 48, your lordship.
Yes,
Permitted to withdraw the writ petition.
take that. The memo is filed stating that the petition is not interested to withdraw the petition. Accordingly, dismissed as withdrawn. Yes.
One submission, my lord. My lord, filing memo for posting, my lord.
Page
What
number
is the memo for
Memo.
posting? What is that?
They didn't pay arrears, my lord.
Humble submission, my lord. Serial number 13 and clubbed 3 matters, my lord. Kindly take the matter today, my lord. They have sought for adjournment that I couldn't make out that.
Your advocate. Why are you
No,
making
I have filed a recall application, my lord, and in that the reasons why I don't want a legal service advocate is been clearly
Call
specified.
the matter, I'll pass order. Yes.
Page number 1. For orders matter, serial number 1. Abhijit.
There's 2 weeks time to furnish the correct address. So there is
Let's see what is give the order sheet. You have an interim order
Yes.
on 11/2/2025.
Step taken. No. They're seeking for a correct address. Actually, there is the one house of the respondent. You don't have to clarify. Personally, we have served the copy in the trial court. The execution
There are no
file.
other matters pending between the parties?
The execution was pending before the trial.
It's pending.
Pending.
Then serve the notice on the council.
No, copy was served personally on that day.
The petitioner permitted to serve the hand summons on the council appearing for the respondent before the trial court and before the executing court and shall file a memo to that effect. List the matter on 30th of August. Interim order earlier granted is extended till then.
Then number 2, Anantram C.
I'll take a step, my lordship. The respondent has left the house, my lordship. I complied the order, my lordship. I have complied the order, my lordship. That the execution case file was withdrawn before the court, my lordship. The address, the respondent has left the house, my lordship. To serve the purpose. Kindly pass
No
the
other
order.
cases are pending between the parties?
No, my lordship. Case was closed, my lordship.
No other MC, nothing is pending. The needful shall be done within a week before order.
Cell number 3.
Interim order, look at it. It's not a limited order. It's a conditional order. Yes.
Number 3.
Appearing for the petitioner, my lord.
And also record that the learned counsel of the petitioner submits that he has complied with the interim order passed by this court. Yes, next.
Cell number 3.
Appearing for the petitioner, my lord. Interim order may kindly be extended and 2 weeks' time may be granted for compliance.
Postal share unclaimed.
Yes, my lord. We'll
The
furnish.
notice to the, as per the postal share, notice to the second respondent, returned with an endorsement, unclaimed, amounts to deemed service of notice. The deemed service of notice, print the name of the party, the respondent, admit post of final hearing. Interim order earlier granted is extended until further orders.
Much obliged.
Cell number 4. Harish Kumar H.
Yes. Agreed with the order, agreed with the judgment dated 5th March 2016, passed in MC number 281 of 2025. No. MC number 281 of 2015, dated 5th March 2016. The petitioner has filed the present RPSC. Whereby the court had allowed the petition and granted a decree of divorce. The office has raised the issue on maintainability of this petition in view of section 19(1) of the Family Courts Act. There is no representation on behalf of the petitioner. The office objections with regard to the maintainability are upheld, and the petitioner is at liberty to file an appropriate petition within a week. Registry to return all the records. Yes.
Cell number 5. Yama Dire Matter.
Appearing for petitioner, your lordship, kindly grant 2 weeks of time.
2022, you have not paid the process till now, and why should we grant time?
2 weeks.
No, wait 2 weeks.
Address.
So what is the purpose? What is this WP? By this time, the case itself must have been disposed of. What remains? Application under order 7, rule 11D is dismissed. No, the court must have proceeded with the case. Yes, we'll dismiss it. The present writ petition is filed. Questioning the order passed by the court on I number 3, where an application is filed under order 7, rule 11D to reject the plaint. By order impugned, the court had dismissed the application filed by the defendant. This order is dated 17/9/2022. In this matter, court has issued notice as the petitioner has failed to pay the process. The notice is not issued. When the application for rejection of plaint is dismissed in the year 2022, by this time, there must have been substantial progress in the suit. Hence, at this point of time, no orders needs to be passed in this petition. Accordingly, dismissed. Next.
Till number 6. Sharat Kumar GM.
This is a petition of 2023, even till now, the notice is not sent as the process is not paid. Even there is no representation on behalf of the petitioner. This is matter for dismissal tomorrow. Next.
Number 7. Still number 7.
For the petitioner in this case, filed an petition.
Non-filing of memo for having taken out notice to the council.
Indeed, they've taken notice and the respondent have already come on record, filed another writ petition 219525.
We're talking about this writ petition.
Same. Then other writ petition is also filed by the respondent. But they've not appeared in this court. They've received the notice. They filed.
Where is that? What is that writ petition?
That writ petition is for enhancement.
What is the number?
21925 of 2024.
Post along with that tomorrow. Yes, next.
12195 of.
21925
Ask him to write on a paper and give.
24.
Yes, next.
Till number 8. 8 urgent. Till number 9. Fallacious.
I appear for respondent.
I appear for the petitioner. My lord may
This
kindly
is the-
pass over the matter. Since my senior is not here, my lord may kindly pass over.
Who moved the memo?
I had moved the memo.
And then?
He'll come in some time, my lords.
No, even before that, complaints of office. No, when the court is saying that unless the office objections are cleared, it should not be listed. Why they are listing it? No, CH moved. That's how it is listed. Say no. Look at that memo. Open it.
My lord, they are not paid the arrears of maintenance, my lord. And this honorable court has disposed the matter as per annexure J, page number, kindly peruse page number 53, my lord.
Password.
Much.
Look at it. And whenever the memos are moved, office objections not complied, not to list. Yes.
Still number 10. May Salma.
Your lordship, and someone has been given, your lordship, through police station as well as in the trial court, your lordship.
Have you filed the memo?
No, your lordship, they have not given the acknowledgement, your lordship. The open court have given the.
What is police? I said hand summons.
Hand summons, your lordship. They have not.
They are not hand summons. They will use.
They did not sign, your lordship, and the police denied to sign it, your lordship. They personally called the respondent and gave it in.
Counsel is not appearing.
She is appearing. They have changed twice. They have changed the counsel.
No, sir, the notice
No.
on the counsel appearing.
Your lordship, she spoke to me recently, your lordship. I even.
All that court cannot consider. You have to file a memo before the court. You have to serve it in the procedure known to law.
Tomorrow, Your Lordship. And Your Lordship, since 6 months, the trial court
Petition is
has.
permitted to take out notice on the counsel appearing before the trial court and shall, for the respondents, and shall file a memo to that effect by 22nd or
Your
by
Lordship,
29th.
this
By
week,
the
Your
time
Lordship.
if the memo is not filed, the notice to the petition shall stand dismissed. Yes, next.
Till number 11.
I appear for the
Appear for the
respondent.
Lordship. The
2
petitioner,
days time may be granted to swear the affidavit. By oversight, it was filed.
the
And two,
affidavit your lordship
two.
had indicated last time, the days on which the visitation is missed, that is on a second Saturday, the same has to be compensated on another Saturday. They had
that can be
to file
allowed.
an
The
affidavit on that regard.
Is only on the office objections. We'll hear it on the.
The
bench.
modification can be done. I have no objection to
Let them,
First of all, complete this office
Please.
objections and come before the court.
Please.
a short date.
Objections shall be complied within 2 days.
2 days.
2 days versus matter of complaints of office objections.
Much.
Kindly a date may be fixed, your lordship.
It will come 2 days. After that, it will come.
Please, your lordship.
Yes.
Till number 12. Till number 12. KP Bhuvan.
My lord, week's time may be given, my lord. I have served copy to the trial court advocate, my lord, but they have not filed wakalat, my lord. This,
There is that memo that is sufficient.
my lord. Are not filed.
Where is the memo?
Memo not filed, my lord.
Please.
Please, my lord.
That's the order to file the memo.
Please,
The petitioner shall file the memo.
please, my lord.
Who is this one? The petitioner shall take out hand summons on the counsel appearing for the respondent for the trial court and shall file a memo to that effect by 29. If the memo is not filed, the petition shall stand dismissed without further reference to the court. If the memo is filed, list the matter.
Till number 13.
Please.
Till number 13.
Yes.
Okay.
Yes.
My lord, in WP 2372, last time there was a direction to appoint the legal advocate. So
Only the direction. This court has said from here onwards, you shouldn't appear as a party in person and waste the court's time. Not only that. Yes.
I have filed a recall application.
Where
My
is
lord,
that
because
application?
IA 8 of 25.
Take that. 2302 she's saying.
230.
2. In that she filed an IA. Get that.
IA number, madam. IA number.
8 of 25.
In which petition?
My lord, in a previous date, Justice Yerur has made an order that to file an application regarding the child's school fees in the lower court and to come. So I have filed that application in the lower court and they have not granted the fees. And that imbued order also I have filed here.
That cannot be filed in this. That cannot be. That's what I am telling you. You do not understand the procedure. Without a procedure, because party in person is appearing, we cannot pass orders.
My lord,
You
then
cannot
Justice Yerur directed me to file an application and to come here.
He has filed, that means he has asked you to come in not in the same application. If that order is not, if they have not considered your case, then you have to come before the court by filing a separated petition.
My lord, in that 3 IAs which I am challenging in that, my
No,
lord,
let
it
me
is
look
being
at it.
disposed.
Let me look at it. Let me look at it and I'll answer what is that.
Ma'am, IA 8 of 25 in WP 2302.
Yes, come to that IA. What did you say?
IA 8 because my lord, earlier one legal advocate was appointed me in the content petition.
Let me look at it. Please read your affidavit.
Okay. I submit that advocate Archana, so and so phone number was appointed as my legal aid advocate earlier in content petition but colluded with respondent advocate who prepared and forced to sign in memo to withdraw content petition against the
File a
respondent.
complaint against her.
Yes, my lord, and she has been removed also because she is the one who directed me to file a contempt against the judge, my lord. And she also prepared one memo for withdrawal telling that I should withdraw the contempt petition against the respondent also. Then soon after that, I have filed an application to remove.
No,
She
please
also filed a
understand,
memo for retirement.
believe in the legal services, advocates appointed by the legal services, you have your time on your case. That's not possible.
My lord, my IAs have been disposed. That is the rules, whatever is mentioned in that. It is the rules which is followed under the civil practices.
Where
It
is
is a
that?
criminal petitions, my lord.
Please, let's
In WP 230.
You cannot teach the court what is the procedure. First of all, you
Oh,
don't
my
know
lord,
what
my
is the
lord,
procedure.
why? Because, my lord, 1 year before I have filed this, and Justice Yerur has clearly heard the arguments and also told in the court hold an order will be passed. Then again, it is released from part heard, my lord. And 1 year I am behind. If it is not maintainable, then in the first instance, we should have been like disposed.
It is not, that's what I'm saying. It is not argued like that. If Justice Arur has not done anything, that doesn't mean that this court also has to do the same thing.
Okay, my lord, shall I come to the?
Please read that, and you have to
No,
complete
no,
it.
my lord, the impugned orders can I read?
You have to first of all recall petition. Recall petition, what are the reasons to recall? You argue in 5 minutes. I will look at it. Unless and until the petition is recalled, question of hearing you will not arise. You filed a recall petition, isn't it?
Yes, sir. Application.
Why the order has to be recalled. When if I am satisfied, then you will argue address the arguments. Otherwise, you cannot. Yes, where is that? Please read the affidavit. What are the reasons for recalling the order?
I submit that Advocate Archana so-and-so phone number was appointed as my legal aid advocate earlier in contempt petition, but colluded with respondent advocate who prepared and forced to sign in memo to withdraw contempt petition against the respondent and given misleading advice to file contempt petition against third additional family court judge, which was partially done by the petitioner, who was a law student who realized later that it was a trap not to get any justice and withdrawn. I submit that the respondent has based this marriage entirely on fraud on 8/5/2006. He has willfully cheated me. The petitioner, very well aware of his condition of impotency, but was married about 17 years ago, suppressing the fact. This is atrocious that a condition as grave as that the petitioner tried to hide from me and my family. Each and every member of respondent's family are forced and cheaters, and that respondent's mother, being a woman, instead of sympathizing, joined hands with her son to see my life ruined at every hour of every day. I submit that Lalit Mohan versus Union of India 2018-10 ACC 1, the Supreme Court observed that a recall application can be filed if new evidence comes to light. I submit that no interim maintenance or protection or compensation awarded till date and failed to take evidence where PW1 affidavit filed on 24/7/2023 and many applications pending from 2 years, making the petitioner and minor child to starve to death or risk of safety and survival and violation of fundamental rights. I submit that the opposite counsel appearing in respondents matters defame me, threaten me even in front of third additional family court judge Bengaluru, which makes me almost lost my faith in judiciary. I submit that the opposite counsel, by colluding with my earlier legal aid advocate, made a submission not to allow me to appear as person who was removed later, misusing her position as senior counsel, defame me in my written criminal petitions, which is around 30 cases in number, and makes number of false submission where such videos after being edited are circulated in YouTube, where I have depicted as a monster, being compared to other Subhash's wife, where I get murder threatening, which even made High Court justice to prevent me even by making submissions that if I talk, I will be held in contempt. I submit that due to communication breakdown and lack of confidence, I have lost confidence in my legal aid advocate, as earlier number of advocates cheated me by even changing the petitions with false signs. I submit I have filed applications after seeking professional expert advice, and I will be more vigilant in future. Wherefore, I respectfully pray that this Honorable Court that this application may kindly be allowed and recall order dated 3/7/25 to and remove legal aid advocate and permit me to represent myself in the interest of justice, accuracy and equity. My lord, when last time when that contempt petition, when that advocate was finally removed, before that opposite counsel did not know that she was being removed. She took a copy of that order and she submitted before Justice Yerur also to not to allow me to talk as a person, but to appoint as a a legal aid advocate, with the help of a legal aid advocate. Then in front of Justice Yerur also I made the same submission. My lord, I cannot keep on running behind the court and the advocates, because in Kerala, my advocate, whatever my petition, she has taken and she has changed the entire petition. Whatever the alimony I have asked, she has changed it into like 5 lakhs. My false sign has been put and then she has filed that. Whatever I have signed and given, she has not submitted in the court. And after filing like copy application, that I came to know after 6 or 7 months, my lord. So only my case is being dragged like anything for like 7 years, 5 years, my lord. And
To appear like party in person for the next 10 years, it will go on and you will not get a relief. That you are not understanding.
my lord, High Court has given good directions, my lord. Even in January, Justice Yerur has given a direction within 2 months to expeditiously dispose the matter. Still, my IAs have been pending, in which
Even if the courts are burdened with lot of work, every petition you file cannot be disposed of like that.
my lord, 3 years, my child was homeschooled.
There are matters pending from 2012-13 also in the family courts. So you cannot ask the court to do everything in the time frame.
My lord, in my case, there is a nullity is there in this writ petition. The last time which is been disposed, in that Justice Krishna Dishis has given a whenever there is a nullity background is there, to expeditiously dispose the matter within 1 year. There is a direction is also pending, my lord. And whenever my IA for impotency test from past 5 years, it is not being allowed. So it is being pending from so many days. If that IA can be allowed, and
This court will allow. This court will allow that IA. In a writ petition, first of all, you file a writ petition for a expeditious disposal. Justice Arur has passed an order.
Yes.
Thereafter, you say that the judge has not disposed. You file a contempt petition. Thereafter, you will file a petition to recall Justice Arur's order. You will file a petition to send your husband for undergo the impotency test. You will file a petition for interim maintenance in this writ petition in the IA. Can all that be done? That's why I said you do not know the procedure. Go to the advocate. And if you say you do not have any faith in the legal services advocates, then I'll say you will appoint your own advocate. That's the only remedy available to you, nothing else. We cannot waste your time. There are so many people who are waiting. And with all these bundle of papers, all objections, 101 objections, because nothing is maintainable. And that's why I pass a reason order in all these. I do not find any reason. Please come.
My lord, I will appoint an advocate. My advocate will file to the end of the day.
I'll write that. On 3/7/2025, this court, after hearing the party in person, had passed an order wherein this court has observed that the party in person is not able to understand any of the procedure that is required to be followed, and she's unnecessarily wasting her time and also the court's time. And because of the lapses on her part in understanding the procedure, the court's time is wasted, and she is also not in a position to get the order from the court. And the party in person is advised not to waste the court's time like this, and she shall approach the legal services authority. The court has also observed about how the IAs or unconnected IAs are filed. And it's observed that today several petitions filed by her are listed before the court. And in all the cases, she is seeking the relief which cannot be granted. And the court can understand her anxiety to get the relief, but there is a procedure and the way to get the relief from the court. And the manner in which she is filing the petitions and seeking the relief, the court cannot pass any orders to grant relief as prayed for. And accordingly, and directed her to approach the legal services authority, and the legal services authority shall appoint a legal aid counsel to represent the party in person, and directed all the petitions to be listed once a legal aid counsel is appointed. Now, an IA is filed. What's her name? The legal services authority has appointed so and so. Now an IA in WP number 2302 of 2025 is filed, I number 8, under Article 226 and 227 of the Constitution of India, to recall the order dated 3/7/2025 and to remove the legal aid advocate and permit her to represent herself in the interest of justice. In support of the same, an affidavit is filed. It is stated that she lost hope in the system. It is stated that earlier her legal aid advocate had colluded with the respondent counsel and made her to withdraw the content petition. It is stated that, and she has also raised made allegations against the senior counsel, and basing on this, she submits that she wants to appear in person and she do not want to hire any advocate from the legal services authority. It is stated that earlier Justice Arur has passed, the other bench, a coordinate bench of this court, has passed an order whereby she was asked to approach the court for seeking maintenance, and if the maintenance is not granted, she can come back to the court. Hence, she has filed a recall petition and further IAs in the said writ petition. It is submitted that the order dated 23/7/2025 may be recalled. This court has heard the party in person. On the last occasion, when several writ petitions are listed, and looking at the office objections that are raised, looking at several IAs that are filed by the party in person, and the way in which she is, and she is not able to understand how she can get the relief from the court, and filing applications which are not at all maintainable. This court has passed a detailed order, and the Legal Services Authority has appointed the counsel. Now it is submitted that she wants to appear in person, and she do not have any confidence on the legal counsels appointed by the Legal Services Authority. If the party in person has no confidence on the advocates appointed by the Legal Services Authority, the only remedy that is available to the party in person is to appoint an advocate of her choice. But this court will not permit the party in person to represent, will not permit the petitioner to represent as a party in person. She has initiated all these. When is the MC filed?
I have filed MC in Bangalore 2023, my lord, in Kerala 2021. That
Kerala,
execution petition of that order is also
Bangalore
pending.
2023, and even till now, according to her, her IA for interim maintenance is pending. This court is able to understand why her applications are pending, looking at the applications that are filed before the court. In that view of the matter, this court is not inclined to recall the order dated 3/7. In that view of the matter, the order dated 3/7/2025 is modified. That the party in person, the petitioner party in person, can appoint a counsel of her choice, but she cannot be. But she can't be permitted to appear as a party in person. And when do you want?
Today, end of the day.
No, it's not possible. This is matter day after tomorrow.
Tomorrow.
Day after. Yes. Oh,
My lord, not the interim maintenance, in the other divorce petition, can I make
Please
some?
come along with your advocate, then we will see, not now. Next.
Number 40. Annapurna, Gurappa, Vallali.
For the respondent in this case, my lordships.
Now they have given the copy objection.
Interim order earlier granted is extended till the next date of hearing. Yes, you were asking for adjournment.
Yes, my lordships. I've served the copy, my lordships.
Just now I received that.
Raised on objection, that is copy served. Then counsel for the respondent submits already the copy is served on the counsel. What is this affidavit not forthcoming?
My lordships, for the objections, I need to file an affidavit, my lordships.
That objection has to be complied.
I do that.
Because that is complied, and the second objection shall be complied within a week.
A date may be fixed, my lordships.
This is matter on 29th
Obliged.
May.
Then number 15.
Entry order mechanic.
Interim order earlier granted.
Respondent, my lord.
For the petition in this matter, my lord.
My lord, I filed the objections. There is a objection raised by the office. Actually, my respondent is an army officer. He's posted in Kashmir. I'm unable to file the affidavit. It may kindly be overruled or 3 weeks time for objections.
To file it. The office objections shall be complied with within 2 weeks. Once office objections are complied with, list the matter.
Then number 16. Ramachandra Putta.
I pay for the petitioner, my lord.
Yes.
My lords, on the last date of hearing, an affidavit was required to be filed with the court. We're presenting the affidavit.
Have you served the copy?
Copies have been served.
Have you seen?
No, I've seen the affidavit virtually read. The agreement between the parties, the mediation settlement agreement.
Take that affidavit. Suppose that the audio at the senior counsel send should be rectified. It's creating problems.
I will get it done, my lord. I asked my technician to come. By next week I'll get it done, my lord. I'm sorry, my lord. I am extremely sorry. Otherwise, I'll start coming to court. My leg is accident, my lord. That's giving me trouble. That's the only reason I can't appear in the court. I'll come, my lord, from next time.
Please come to the court. Would like to see you in the court.
I'll come next time, my lord. I'll come, my lord.
Canara Housing Limited Company, in which the amount of rupees 50 lakhs is invested by me, what to be closed, or if anything happens to that company, it would be my responsibility to ensure that the respondent would receive the monthly maintenance, which she now received. That's what he wrote in the affidavit.
Correct, but the agreement between the parties is there'll be a corpus which will fetch 1,10,000 rupees per month. Now, my lord, the petitioner is saying if the deposit of 50 lakhs is diminishes or the company closes, anything happens to deposit.
That means that 1,10,000 or whatever is assured, that will be paid by.
Well, kindly see, my lord, the decree passed by the court is the corpus must fetch 1,10,000 rupees. The 10%, there's a 10% annual increment on the 1,10,000 that can be paid directly.
Whatever may be the amount, I'll give. My lord, I have been give. My lord, 2 minutes, my lord. I have been paying 15 lakhs for the child, plus 9 lakhs for the sports activities. Then conveyance I'm paying, my lord, total 58 lakhs I'm paying for the child. He wanted me to change the school from 2 lakhs to 15 lakhs. I've been paying. Well, I'm not shirking, I'm paying every month.
No, what it can, no, this paragraph number 3,
Yes,
it can be redrafted and you can say that, like, in case, like, whatever, as per the terms of the decree.
Yes, my lord.
If any case, if that amount is like, when it is closed or anything happens to the company, in the same terms, same terms, you will take the responsibility.
Yes, my lord. I will do it, my lord. You will ask me same, my lord, I will do it.
No, whatever that is there in the decree, now you have to, as it is, take it and add it that in case anything happens, that's my responsibility to again, get it into place, the same clause.
Yes, my lord. I'll do it, my lord.
Then the senior counsel appearing for the respondent, appearing for the
Petitioner.
petitioner submits that as per the order, not that, as per the order passed by this court, an affidavit is filed by the husband. Then counsel appearing for the respondent submits that it is not in terms of the decree that is passed by the court. Then senior counsel appearing for the husband submits that they'll file an appropriate affidavit, incorporating the clause as it is there in the decree, and with an undertaking that if the company is closed or if anything happens to that corpus, it would be the responsibility of the husband.
To create one more corpus. To create another corpus, because the corpus it says there must be a corpus which will fetch 1,10,000 rupees per month. That is a decree between the parties.
Well, in accordance with the decree only I will do.
Whatever is that condition, it will be there, and they will say if anything anything happens to that company, they will take all the steps to see that the same corpus is created and carried forward.
And in the event the corporate, if there's anything that happens with the corpus, as my learned counsel just stated, that we are required to make good of that deficit amount, which would have normally fetched by the corpus. to the wife, which normally would have been
Whatever,
fetched.
what happens if something
It's
happens
part of
to
the decree.
No, something happens to this. Then, you are undertaking before the court, that you will create another corpus, not that ensure that you will get something. From the corpus, you should get.
That was, it's part and parcel of the decree, despite the undertaking.
What
It
is
was
that?
even without the undertaking, this was part of the decree.
Is it so?
Not what the decree says is a corpus must fetch 1,10,000 rupees. First, he must make a corpus that fetches 1,10,000. If the interest from the corpus reduces, then he will make good the difference. This is different. No? Corpus has to be there to fetch 1,10,000.
Yes,
That's the decree
yes.
says that.
When do you want? Senior counsel.
Yes, my lord. My lord, in conformity with the decree, my lord, I will continue. Your lordship will say, my lord, as per the decree, I will do it.
Yes, when do you want? When will you come up with the next affidavit?
1 week time I granted. Next week I'll do it.
Yes. This is a matter on 24th.
Yes, my lord.
27.
Yes, next.
Cell number 17, 17 disposed, 18. Cell number 18, Mahesh BJ.
Sorry for the delay, my lord. I have served the copy on the council. If your lordship permits, I will file it in the office.
It is submitted that as per the order passed for this court, already the notice is, had summons was served on the counsel for the respondent, and he will be filing the memo today. This is the matter day after tomorrow. Yes, 19.
In the meanwhile, my lord, the interim order may continue.
Look at it. Wherever interim order is there, extra. Yes.
Cell number 19.
I appear for the respondent. I am for petitioner, my lord. I'll file that acknowledgement because we have transferred the amount, my lord, whatever the honorable court been ordered, but immediately they have sent it back as my instruction. Today I took the instruction.
You don't want to
I am not having such instructions, my lord, but
Please
I
find out if she really
Yes,
does not want the
no,
money, we will allow
that-
his petition.
no, it is not with that.
The counsel appearing for the petition submits as per the order passed for the court, he has transferred the money and the respondent wife had retransferred the said amount. Then counsel for the respondent submits that.
I
he
will
has
get
no
an instructions.
And he'll get instructions in that regard. This is matter on 22nd.
Obliged.
Cell number 20. Fatima SK.
Look, this is
Siji
the
Malai.
jurisdiction aspect of the child. What are the judgments you are relying on?
Plus, have already submitted judgments of Supreme Court and our own high courts where it is held that wherever the child has resided, making it the permanent place of abode by the parents is a jurisdiction ordinary residing. And that is Pune in this case, because a child was born there, conceived there.
If I remember the facts last time, what you said is within 2 months he has come to India, come to Bangalore and filed the MC.
Yes, my lords.
India
She
definitely.
left Pune on 18th April or whatever, came in May 2024, from what facts that we ascertain. She stayed in her brother's place and in June she filed this custody petition. So I file an application order 7 rule 11 saying this court does not have jurisdiction at all. It is a court at Pune that has jurisdiction. But the court has dismissed the application.
What are the judgments you are relying on? Dated, when did you file your objection? Yes, I have it. Yes. Yes. No, there is no dispute that you are staying in Bangalore. One minute, let me look at it. Yes.
It's introducing case number 48 of 2025.
Yes.
This is filed on 7/1/2025.
7/1.
2025.
Hmm.
Page number 31, Lordship, the client's address is provided. It doesn't disclose this.
When did you file your?
I filed it on 22nd, sorry,
28/6/2024.
When did you enter? When did he enter appearance?
Plus he entered 1st of September 2024.
Then why did you not mention the address of the lady in that?
Milords, not this, he's talking about the petition in the Pune, Milords.
That's what, you find it much later. When
Plus
not-
there the issue was, later he has submitted this thing, I can produce that. There the issue was, they had to produce the Aadhaar card or proof of whatever it was. That is the reason this was mentioned, and subsequently he has given, I can produce that.
That's one. Next.
Then the honorable family court in Pune issued a summons. And because I appeared on the Supreme Court, stating this, the petition, stating the challenging the jurisdiction itself, primary ground in this challenge.
How can the jurisdiction be questioned in the Supreme Court? You should question it before the court, with who, before whom it is pending.
Pune doesn't have a jurisdiction, have a jurisdiction in Bangalore. Because I am deciding.
Then what did the Pune court do?
Pune court issued a notice summons to me. Appear before the Pune court. Then thereafter I approach honorable
So it is, a stay is granted as far as the Pune court is concerned.
Yes, ladies and gentlemen, this is suppressing the fact that I residing in Bangalore, we filed a petition and issued a summons. The same thing I have said. Stating that I am a resident of Bangalore, my child is more than 1 year studying in Bangalore, I am working here, I have unfortunately this background based what has happened. Series of episodes of violent behavior. It is not that one day it happened, petition also, since the end of this petition, I am not narrating it, like that, what has happened. Because I am not a resident of Pune, neither I have a relative or a friend. Neither these are not a resident of Pune. On the work of few years they stayed in Pune.
Few means how many? Few means how many years?
Considerable amount of time based on 5, 6, more than 7, 8 years.
Boys, what is the age of the boy?
Child, girl child.
Girl child. Girl child, what is the age?
She is 11 years.
So, like, for 7 to 9 years, she stayed in Pune.
Yes,
That girl is,
she stayed.
so almost she stayed in Pune. Girl stayed in Pune.
Please, my God. My visa is my Lord. That's a threat to my life. I am alone. Lady, you don't stand there. Staying in there. My address of the big influencing person. There is a threat to my life. First, I took a shelter to my parents' house in Pakistan. My parents moved to Bangalore. Because even they came to Bangalore, he had come to my house, trespassed in my house, and there is a threat. I was summoned to police.
No.
So
No. Please understand. Before going to all other facts, I do understand. Like everybody has their own reason to come out of matrimonial home, and they have their own reasons to stay wherever they're staying. But here the question is, what is the ordinary place of residence of a minor? You are filing a petition under GNWC. Section 9 of the Act deals with jurisdiction. So we have to now, if all these reasons, then the legislature has to amend that or that section 9. What are the interpretations that are made by the Honorable Apex Court with regard to this is the only question that we have to see. Now, if you have all these reasons, as you have gone to the Supreme Court and got the stay of Pune proceedings, as well, you could have gone to the Supreme Court and whatever, filing a petition at Pune, should have gone to Supreme Court and said that no, as per the Act, it is at Pune, but I am residing here, I have a threat to my life, please transfer the GNW proceedings to Bangalore. That could have been asked. Now, whether what is not permissible by the Act, can we do it is a simple technical question. We are not going into the facts of the case.
Both the petition, where is the Karnataka check? What he's asking for custody of the thing, I'm also asking this.
What will, it has got a, it's not a simple issue. It's a larger issue. Any order that is passed by this court with regard to that jurisdiction on a basing on a facts and circumstances of a particular case, it would have a consequences or
My authorization is Bangalore now, because I took a shelter in Bangalore.
that's not called ordinary place of residence. That is what the Honorable Supreme Court, that judgment that is in a transfer petition between the both the courts. In a court, High Court in a transfer petition has dealt with that. Now there is a judge, there are judgments of the Supreme Court which you have to rely on that because there can't be a law by this court contrary to the Supreme Court judgment. Why should we? No. Please understand. Why should the judgment we look it from our court? We look it from the Supreme Court judgment as it is. Let's look at it. Please tell me what is a judgment.
Lots, I have.
Because on the law we need to be very clear.
There is
that I've seen. Yes.
Even Surinder Kaur, Lots. There are several judgments, in fact, of Supreme Court which deals with this issue. I'm sorry.
Which judgment you are relying on? Richi Manju. You have filed that.
But I have not filed Ruchi Manju.
Take that. Ask the judgments from the chamber.
The parameter 21 member. Guardians of what upon consideration of the matters, business application has corresponding to that. Interior records sufficiently show that consent to the arrangement that they approved by for reviewing in order to explore the carrier options in minor was to remain in custody of the and was to be admitted in the school. The court further emphasizes the existence of a relation regarding the contract applicant is added to question whether the interest of the minor would be served better by his mother as a guardian has to be retained. It is the light of the government and the question whether
The reading paragraph number?
21 members.
Yes.
491.
Yes.
I think that group number 26.
Yes.
You may, before going examining the group expression ordinary result, here in section 1, the expression has been used in a different context. It has also come up for its interpretation. Since the liberal interpretation is the first and foremost rule of interpretation, it would be useful to understand the liberal meaning of two words that comprise of expression in the word ordinary has been defined in this one. First, I want to read it again in terms of definition as it. Let's skip to page number 29.
Yes.
Suppose for dealing with the case under 4
I think you can come to paragraph.
Definition of residence and ordinary residence. That is what ordinary residence and residence. The court notice that near the of the meaning of that meaning meant by the use of the word residence appear to be the provisions that residence implies something more than a client visit or a casual stay for a particular place. The legal position was summoned up to the following law. Not the thing is here, I'm not the case that I just came there immediately, but I came settle down myself. And
2 months.
2 months, my lord.
What can you say settle down?
Thereafter, there is a threat to my 11-year-old child, daughter, where will I go? He's supposed to take over the child and go having me. So how my option is because
I understand the difficulties. I understand the difficulties. That's what I'm telling you. Facts of the case and the compelling circumstances for the mother, all the court can understand and appreciate. But you have to, that whatever interpretation you are saying is not what ordinarily recites is.
Ordinarily said the intention of the party to say that is what
That is odd, it is not the parties, no, the ordinary intention of the mother to decide will not confer jurisdiction on the court.
Because she cannot go threat for her life and file a petition there. I believe the same thing in my petition filing before this court.
Those are all the good grounds for transfer. Those are all the good grounds for transfer.
Recalculation will also be by that. That is a matter was not the question is arguing. Everything but that before this is not lordship, court is not court. And the board is there also agreed upon the fact that yes, jurisdiction is matter of is pending before the apex court. Let it be decided. If that is allowed, definitely will come here or this matter will go back there. It is that keep the matter pending. That point of view, lordship mechanism case, that being the case, please consider my application just for visitation. That is how the order of visitation was passed. This was understanding. Now I don't know my reference is how something to the matter and how the matter. I have no hesitation or arguing anything. This is the background which was said.
Is it so?
It's not true. I'll explain. Let him complete.
So now lordship mechanism, should I risk my life going to that place because enough and more is I don't repeat it, enough and more explained in my petition even before the apex court, saying that the relief is not by the court for parties are saying it's pending for parties are saying for the court. It is now the only question is whether since the matter is seized with the apex court in respect of the jurisdiction, if any parts or what is transferred to the court, either way it may affect the court. That is where I spoke this solution.
Plus, first and foremost, I did prevail upon the court to decide my petition because it is time is of essence. But the court said since they, in fact, my lords, after filing of my petition, they approached the Supreme Court and do not even mention the pendency of my writ petition in the transfer petition. They don't even mention. It is a suppression of facts that is created by them. However, a stay is granted for the proceedings in Pune. I did make a submission and pleaded with the court that it should not come in the way of disposing this petition.
Oh, because they are independent.
Correct.
Their cases are courts at Pune do not have jurisdiction.
Absolutely,
Courts at this place have jurisdiction.
Absolutely. However, the court was inclined to hear and dispose, but because of time constraints, the court said that I will not be able to hear it right now. And then, my lords, the vacation came. Then the court was just going to dictate the order that the child will be sent to Pune. While dictating, my learned friend pleads that the child has to be kept present. However, the child was kept present and the court said, reversed it to Bangalore. Instead of Pune, the child being sent during the summer vacation. The father came here, spent 1 month. That's a different thing. This is exactly what happened. I do not know why such submissions are even being made. It's all right. That's fine.
Yes. You want to add anything else? That's the only thing. We are not going into any other issues, only jurisdiction. According to your jurisdiction is Bangalore has, because it was decided to stay back in Bangalore, and all the compelling judgment of Justice Nagaprasanna, Justice Srinivas Harish Kumar on the last occasion. Yes, I'll pass. Heard, reserved.
Plus, in fact, our own High Court, Namita Puvayas is, I think, one more. Of course, there is. I have produced several judgments are there which I have also produced. That is one Namita Puvaya versus.
Let us see. No, give all those judgments separately so that let me understand what it is. So, who is relying on Justice Nagaprasanna's judgment?
I am relying on Namita Puvaya's and Justice Nagaprasanna's judgment. All this have been given, my lords. I could make a copy and submit again.
No, it's here. He's relying on
I was
Justice
just showing.
Srinivas
I've
Harish
already
Kumar's
given. My lords, I can make a copy. I've already submitted with the memo, in fact.
Yeah, this is here.
Yes, my lords, and this one, the Justice Venugopal Gowda's judgment.
1 minute.
I have an extra copy. I could.
This is a one memo of citation.
Plus that, I think they have given. I'm not sure.
Oh, this is.
I have given.
Huh?
I have given the memo. I can. I have an extra copy. I could. Well, it's already given.
Give it to him.
It's already given.
You want to submit arguments? Pass over. Pass over.
Great, Milaks.
Yes, next. Yes, next.
Cell number 21, preliminary hearing, Somsekhar Reddy case.
Appear for petitioner, my lord. Impugned order is at page number 38. my lord.
30, interim order is there in this?
No, my lord, no entry. my lord. Page number 38. my
It's
lord.
also not ordered till
No,
now.
my lord, no, my lord. Notice.
2024 writ petition. Page number?
38, my lord. Wife has filed.
Directed to pay monthly interim maintenance of 15,000 to the petitioner and a daughter from the date of filing this IA. Educational expenses.
my lord,
Have
as-
you complied with the order?
No, my lord, I'm paying 5,000 rupees, my lord. My salary itself is 10,000, my lord. I'm working as a driver, my lord.
Interim order is not there.
No, my lord, no entry. my lord.
Then what are you
However,
doing
I'm paying 5,000 rupees, my lord.
When is this order? They have not filed the execution.
No, my lord, they have filed execution on the recently, my lord. I just came to know.
2/12/2023 is the order.
Please.
Now, when did you file the writ petition? You will file the writ petition in 2/7/20 on 2/7/2024.
Please, my lord.
And you don't either you pay the maintenance or there is a no stay from this court.
My lord, I'm paying maintenance of rupees 5,000 every month.
That's not the order of the court. You
15,000.
yourself can't make it whatever you want to pay you will pay.
My salary itself is 10,000 rupees, my lord. I filed assets and
Then why
liabilities.
did you
my lord.
come to the
Even,
court with such delay?
my lord, I've moved memo, my lord, 2 times, my lord, but it is listed and it is
No, you filed it on 2/7/2024.
Please.
Order was in December.
Please, my lord.
Anyhow, for all this time you have waited, the petition is permitted to take out hand summons on the counsel appearing for the respondent before the executing court and shall file a memo to that effect. Mrs. Matter, memo to that effect by 31st. If the memo is not filed, the petition shall stand dismissed without further reference to the court. Next.
22 urgent, 23 urgent, cell number 24. Arun Govind Raj for petitioner.
Okay, for the petitioner. Lord, a mother's petition challenging the order of the family court in an execution proceeding initiated by her, where the father, my lord, was directed to file his affidavit of assets and liabilities. That order has been recalled by the family court in an application filed by the father.
There is impugned order.
But impugned order, my lord, is at Annexure J, page 85. But before going to the order, my lord, may I invite your lordship's attention to the decree, mutual consent decree between the parties in 2018, my lord. That's Annexure A at page 14.
Yes.
Could your lordship may kindly turn to page 15, my lord. Clause 6. 6, 7, and 8, my lord, are in dispute between the parties now.
So basing on this, a judgment and decree is passed.
Yes, ma'am. Mutual consent decree is passed in the year 2018.
Then what is the
One of the
what
terms-
is the execution petition? That's fine. Let's look
That,
at that.
my lord, may I read, my lord, clause 7 and 8? That only with regard to clause 7 and 8, page 15. The first petitioner further agrees to pay, that was the father, my lord, a sum of rupees 15,000 per month from 1/1/2018 or equivalent to school fee, whichever is higher, for the education of the minor child till the age of 18 years, and change in school or educational institution will be on mutual consent between the petitioners. But clause 8, the first petitioner further undertakes that in the event he starts earning a good salary, he will, on his own, monetarily contribute further towards educational expenses and other maintenance of the child. Not 2018 was the decree. In the year 2023-24, the daughter does gymnastics. There was a discussion between the petitioner and the respondent to change the school of the daughter. What was 2,20,000 rupees per year annual school fee became 5,65,000 rupees for the first year, and from the next year 4,40,000 rupees. The father goes and buys the application form for the admission in the school. The father tells the mother, in fact, this is the school I was looking at putting her in last year itself. After the mother pays the admission, he buys the application form, child writes the entrance test, she gets into the school. 1,25,000 rupees is the non-refundable admission fee to be paid to the school. He says, you make the payment, I will reimburse it. Once she pays the money, he says, I'm not agreeable to the school, please put her back in the earlier school. So he is refusing now to pay the educational expenses as agreed, my lord, in the decree. 15,000 per month or higher, whatever the educational expenses. The only rider being, my lord, but both parties, it should be by mutual consent, the change of school. The second, my lord, is undertaking is given to the court, my lord, not to me. Clause 8. the first petitioner undertakes that in the event he starts earning a good salary, he will on his own monetarily contribute further towards educational expenses and the other maintenance of the child. Therefore, execution petition was filed. One, my lord, for him to pay the higher educational expenses as agreed between the parties. And second, my lord, the daughter's monthly maintenance had also increased. Therefore, a direction to him, my lord, in terms of his undertaking, to pay enhanced monthly maintenance. The family court, my lord.
Who will determine the enhanced maintenance?
I understand, my lord, whether it would be rewriting the decree. My lord, unfortunately, the agreement is worded in such a way.
It's something which is not executable. There should be a final conclusion of rights between the parties.
True, my lord.
No, it is like forever, like it is a dispute and debate.
The clause is, my lord, worded in such a way that, but undertaking is given to the
Should
court.
have been some like 10%, 5%, some
Correct.
decree should have been there.
Unfortunately, it is not there. It is not there. The education.
What was the salary? No, again, we are re-agitating on a compromise decree now.
No, what happens is this. I am not in the position now to seek modification of the decree because the decree itself provides for modification. Lord, I can always go back to the court, Lord, and file a petition to modify the terms of.
No, I understood this. Now come to your application.
Execution petition, my lord.
Execution petition.
Yes, that's annexure E, page 50.
50 or 83?
50. The order is at page number 85.
50.
50 is the petition. Lord.
No, it has happened now. Now we are asking the executing court to determine the issue and execute it. Now the role of the executing court is to execute what has been decided by the court.
Cannot go behind the decree. That's the order now passed by the executing court. That the sum is not determined for me to go. I cannot rewrite the decree that is there.
The court who passes and executing court both one and the same.
But unfortunately, the decree passed by the court is such. Undertaking is given by the father to the court that I will voluntarily on my own contribute more if my income it is increased. Therefore, I'm also not in the position to seek modification, because if I file for modification of the decree, let's say the decree itself provides that that undertaking is given to the court that he will on his own increase the maintenance. But what's happened is this, the executing court directs both parties to file affidavit of assets and liabilities. I file my affidavit of assets and liabilities. No, they take time to file it. On the next day, they come and file an application to recall that order, saying that if the executing court cannot direct me to file affidavit of assets and liabilities, that would amount to going behind the decree. Therefore, that order is now recalled by the family court.
I would like to attention on the page where the family court clearly mentioned, read out the page 20. Report, see, this is settlement. Report received from mediation center. I have gone to the agreement entered between parties. When inquired, the parties they submit that they agree the terms and is a voluntary. This settlement was clearly agreed between both the parties. And now she has gone beyond the decree and now she's trying to conduct a trial before the executive court by bringing in different allegations about my personal life. And she's trying to run a trial there.
No, let's not go into that. Look at the compromise petition that's filed. In that, according to you, how this
clause 8.
7 and 8 has to be understood?
Clearly, first thing, the change of school has to be a mutual consent. That themselves they have violated. They have filed no objections. There are WhatsApp correspondences to show. Because beyond my comprehension, when I told.
You said so?
Yes, I have submitted WhatsApp correspondences which clearly say I cannot afford this. And regarding gymnastics, I'd like to bring out to this school that the child is not even practicing gymnastics anymore. It is just a plot. It is just a plan to increase the payment. It's a question of jealousy. I have moved on in my life. I have moved on in my life. I am living with someone after my divorce. I have never cheated during my marriage with her. But now she thinks in this thing that he's living with somebody else. His lifestyle is gone up. My lifestyle is not gone up. Two It's a question of jealousy. She deliberately changed the school, made it 5 lakhs, whereas correspondences are there. So we say, I cannot.
That's part of 7.
Yes.
Then what about 8?
8, it clearly says, I volunteer. If it's a voluntary, despite
No,
which,
for that if, what was the salary as on that day and what is your salary as of now?
the petitioner is given, he's unemployed. He's unemployed, despite which he has made payments towards all the credits. This is beyond the settlement. What about payments for 31st 15? Beyond that, he's bought laptops, he's buying medical insurance, looking after our clothes, everything. There are payments have been made, which have been suppressed by her. He's been doing it voluntarily because he feels to that extent he can manage. But regarding the school enhancement to 5 lakhs, he cannot. He voluntarily says, I cannot do that. But rest I am managing. This is what we agree. Suddenly tomorrow, if they say that this child wants to run hospital and put it to some fancy European school where the fees will be 20 lakhs and 30 lakhs, where what do I do? And this has been a repeated thing that she's going to the child in UP when she got her back. And the child is not doing any gymnastics anymore. And if you want to come to their statement of accounts, what they're asking is ridiculous. If you can see from page 29, I mean, Lordship, I brought the attention to the list of breakup. 15,000 for nutrition. Child is not an athlete anymore. Gymnastics coaching 6,000. Tuition for subject items I'm paying for that. Clothes I'm paying. Food and health is not required. She's a grown up child, 16 years old. She travels.
What's her age?
15 years. 15 years old.
And they're asking for yoga, physio, and all those things. These are expenses which are involved in a child who's involved in athletics as a professional.
Mr.
National level athlete, my lord.
No.
She's taking part in the national.
No, all this
No, para 8. I'm only, Lord, my learned,
Yes.
Lord, my learned friend, Lord,
No, it is like as if you're coming up with the fresh statements of SSL
no,
liability.
it is not a fresh.
Something starts with 15,000. That's
Yes.
the only the obligation of the father. No, it has crossed everything.
It is
They
not.
want to-
Well, kindly see, my lord, the first petitioner agrees to pay a sum of rupees 15,000 per month or equivalent to school fee, whichever is higher. Lord, my learned friend says, it's very unfortunate that statement is being made at the bar that the father was never agreeable to this. Lord, I'm sorry, my lord, this email has been shared with my learned friend, I'll share it again. The father writes an email. When she writes to the father and says, this is the school, he says, I wanted to put this. LCR. No, this is an email written by the father.
They are just misleading the score.
I don't have it misleading. I don't make such submissions. You are misleading. Kindly see page 70, my lord. Written by the father to the mother. No, before that, page number 69. The mother writes to the father on 19th of January. Would you be able to make it? My lord, Kunkal's Open School says walkthrough discussion, school tour. Would you be able to make it? I had connected with the school since it was recommended by one of my batchmates from so and so. Let me know if you can make it for this. It will take at least 40-45 minutes from my house. Accordingly, you will have to plan your visit. Also, let's prioritize and go visit schools over the next few weekends. You have a list, you have shortlisted. Both had agreed not school will be changed. To that, the father responds, I missed your email with regards to Kunkal's school. How was the visit and how is the school? In fact, I had reached out to them in 2019, immediately after divorce, and had shared the details by email to you back then. Let me know if you'd like to have a conversation about it. Then he goes.
That's fine. It
Yes.
is nothing, nowhere this email says that the father has accepted for it.
No, he goes and buys the application form.
No, like, where is it next?
No, I have produced
Page 40. He's admitted in his reply.
page 40, my lord. In the reply to my legal notice,
6th of May.
at page number 40.
I think there should be some end to this.
Yeah, no, I understand. But there's a child involved, a 15-year-old girl. And it's very unfortunate for the father. A submission is being made. The child doesn't practice gymnastics. She's a national level athlete, has taken part in nationals. And the father, my lord, is before the court, shamelessly making a submission that she does not even practice gymnastics. Very unfortunate, my lord. Very, very unfortunate. She's a national level athlete, my lord. The school was changed only because this school supports gymnastics. Merely because.
Who shouldn't have passed a judgment and decree basing on this?
I understand, but I was not involved. Both of us were not part of this.
The purpose of passing a compromise decree with these kind of.
Absolutely, my lord. Absolutely. Undertaking is going to the court.
No, but whatever it is, it cannot go beyond that. When his contribution is 15,000 for the, you have given a statement of assets and liability saying that this is, you require 60,000 for the
My
girl.
lord, it is my request, my lord, ultimately.
Which cannot be done.
Absolutely, my lord. But the father, my lord, has said that if my income increases, I undertake to monetarily contribute higher. My lord, the question I ask myself is this:
So you're saying
what
that he is a-
prevents
no,
him,
no,
my lord, from filing?
that he's unemployed. He's unemployed. Let him file an affidavit before this court. Will dismiss their petition.
After the execution, he becomes unemployed.
Because this kind of.
But after the execution is filed, my lord, he becomes unemployed.
Till when he was working? What was your salary in last year, July? Huh? And how much was it when you have taken this divorce in 2018? Last year, no, it was a lakh more than that. No, before this court, you please place before the court, what is your contribution towards your daughter? No, I know, you can produce it here as well. So the learned counsel for the respondent husband submits that, father submits that he has been contributing, apart from what has been agreed in the compromise memo, he has been contributing it to the, he is making contribution more than that towards the education of the daughter. It is his case that he is unemployed. Learned counsel for the respondent, learned counsel for the petitioner mother submits that as on after filing the execution, he has become unemployed. And as per the terms of the decree, whenever he has undertaken before the court, that whenever there is increase in the salary, he'll contribute more for the welfare of the child. Learned counsel for the respondent shall place before this court what is that he is spending towards the child's child's expenses, and also an affidavit with regard to that he is unemployed as of now. This is matter on 28th July.
28.
28. Yes, next.
25. So now.
Petitioner, my lord. Senior is held up in another court, my lord. It may kindly be passed over.
Pass over.
So please.
Yes, 26.
Cell number 26. Ravi Shankar A.
No representation for dismissal tomorrow.
Cell number 27. 27. SP Swami A.
Petitioner. This petition is preferred against the order passed by the trial court by modifying of the order dated 29/3/2025. The trial
It
court.
is a page number, order page number.
It is a ink page number 10.
I number filed with the respondent is hereby partly allowed. Is directed to pay 5,000.
But very meager amount has been passed by the trial
You're
court.
seeking enhancement.
Enhancement.
Notice to the respondent.
Cell number 28. Ali Shankar.
But I am appearing for the petitioner in this matter.
Yes.
That the respondent wife has filed the divorce petition, that MC number 1104 of 2021.
What is the impugned order?
The impugned order is that your lordship may kindly come to page number 17, 18, 24 to, sorry, 16, 24 to 2025, page number 16.
Issue delivery warrant against JDR to vacate and hand over the vacant possession of the property referred in condition number 7 of the mediation settlement agreement. Dated 19.
Delivery warrant has been issued by the execution court. What had happened, that respondent has filed the MC petition for seeking divorce. And the respondent has appeared. Thereafter, it was referred to mediation for settlement. And accordingly, both husband and wife have filed the memorandum of settlement. As per the settlement, some conditions are imposed, formulated in the settlement there. And one of the
The settlement.
that your lordship may kindly come to page more that 21 more that.
Let's see the settlement, terms of the settlement.
That
with
in
regard to
the
this property.
that more that there was no claim. Your lordship may kindly see that fifth mal that condition number fifth page 23 mal that. Both parties agreed that they have no claims of maintenance permanent alimony against each other, either post, present or in future mal that. This is the condition mal that.
Now, before we go to this, please come to the execution petition that is filed by the respondent.
Please, execution petition is mal that annexure A mal that. Page 12 mal that. The short point is that mal that there is a child mal that one child that 13 years old mal that. That child is with the petition.
Or the execution petition. Where is the affidavit filed? In the execution.
That he has not filed affidavit. No.
Petition means they will file something on these reasons. This has to be executed.
That's may I submit mal that. What happened mal that child with the father mal that. Now both of them have not acted upon the settlement that arrived in MC petition mal that. Now what happened mal that child is not ready to go with his mother mal that. Even that father is ready to send. Please
Before you
mother.
go into that,
Please,
when you want an order to be executed, what you do? You will file a petition before the court. Is it not?
This she has filed the petition mal that.
Where is that petition? I'm asking. Where is that petition for execution?
Please mother. I'll show that mother. I filed the execution petition copy mal that at page annexure D mal that. Page 28 mal that. That page 32 para 4 your lordship may kindly see affidavit mal that. I submit that in of the above settlement I agree to withdraw the following cases filed against the judgment debtor. She has not withdrawn mal that. And one more condition is the father has handed over the child to the mother mal that. The child is not ready to go with his mother mal that. Then accordingly after that mother she filed the execution petition and seeking delivery of that house property mal that. The child is with the father mal that. And annexure F earlier mal that this honorable court mal that produce the order copy mal that. Annexure F is the order passed by this court mal that.
Please come to page number 22, point number 7.
Please mother.
Please read that.
Para number 3 mal that.
Point number 7.
The respondent agreed to vacate, hand over the vacate premises bearing number so and so mal that. I will agree mal that. This condition was formulated in the memorandum of appeal mal that.
So there is no problem to execute this order.
My mal that, my submission mal that. Both have not acted upon mal that. What had happened mal that? She has not withdrawn the criminal case. Your lordship may kindly see para 8, your lordship para 8 of that memorandum petition mal that. Para 8 your lordship may kindly see.
She has filed in the petition that she has already withdrawn. In the affidavit that is filed before the executing court.
No, my lord, in the affidavit, your lordship may kindly see that. I will read it, my lord. She has filed the affidavit as per the conditions, my lord. In
She
the
said,
said,
paragraph number 4.
I submit that even of the opposition, I agreed to withdraw, my lord. I agreed to withdraw, my
The
lord.
next, please read the next paragraph. As
And under
undertaken.
before mediation undertaken by before the mediation, I have withdrawn the above cases as per the settlement, but I have not withdrawn the criminal miscellaneous number 64, 2023, pending before the fourth additional so and so in criminal 166, pending before the so and so, and that section 12 of the DV Act has not complied in terms of the settlement.
So why,
This
what
case,
exactly both of you are doing?
only short issue, my lord. The child is not ready to go with his mother, my lord.
Still he has to go. Even if he is not interested, let her take the police protection and take the child. What is this? When you have entered, no, you can't
So
use
what
that the
happened,
child
my
is not
lord?
interested.
The father and child residing in the same that scheduled property, my lord. What they are seeking delivery, my lord. Suppose if the warrant has been executed, my lord, father and child will come to street, my lord. Where is the
Child will stay with the mother. And
unless
father will
he
take
is
his
not
own.
ready to go with his mother, my lord.
What is his age?
For 13 years, my lord. He born in the year of 2011, my lord.
Why did you enter into compromise with this?
That child is.
You should have asked the son before doing it. You entered into a compromise and now you
Both
conveniently.
husband and wife have entered into compromise in terms of
Oh, please come to the impugned order. I understood what are the facts. Come to the impugned order.
both of them have not acted upon, my lord, in terms of the settlement, my lord.
Then why both of you are coming before the court? By wasting court's time at one round?
In spite of she filed the affidavit, my lord, she has not withdrew the follow that
Please
petitions,
come
my
to
lord.
the order that is passed by the court. Please read it.
Please, my lord. That page 16, my lord, 16 onwards. Both parties and both counsels present PF paid and sought issue delivery warrant against the JDR. Peruse the prayer sought in the executive as well as in the mediation settlement. The agreement whereby as per the conditions number 7, the respondent had agreed to vacate the premises and or the vacate premises to the petitioner. Memo with bank statement produced on behalf of the respondent, copy served. The advocate for JDR submit DHR had not complied the other conditions with regard to withdrawal of the other cases pending between the parties. Advocate for DHR submit that other cases were not withdrawn as JDR are not complied the conditions of handing over the vacant possession. The peruse the mediation settlement agreement dated 19/2/2000 whereby both parties had signed the agreement and based on the settlement terms MC number so and so got settled by granting a decree of divorce. J&W
Say that she has not complied with the order. You would have also filed an execution petition. Now what appears to be the intention of your client is to retain this property and stay in that. Notice to the respondent.
And sought for interim prayer, mother. Because of that, mother, suppose that mother order has been executed, mother, it is very difficult on the part of the.
Because I do not find any reasons to stay that order. Notice to the respondent.
Number 29.
That what had happened, mother, may I make one submission? Earlier.
With this, like the parties cannot be permitted to play with the process of the court and get an order from the court. Then both of you on your own do starting doing things contrary to the orders of the court and again come to the court to and seek orders from the court. Why court has no other work? No. Notice. Next one.
29. Akash Yadav for petitioner.
For the petitioner.
Aminullah.
The last date of hearing, my lord, I filed a memo of calculation, my lord. The lordships had directed me to file a memo of calculation.
Yes.
Copy is not served, my lord.
So what is the purpose of not serving the copy and again getting the matter listed? Then counsel for the respondent has served the memo of calculation, the counsel for the petitioner. This is matter on 5th of August.
Great.
Then who stopped you from giving it to him? You should have given your calculation memo. I understand, but have you given it to him in advance? You would have heard the matter now. Now you are giving that, he has to get instructions from the client.
Any shorter date may be given, my lord.
List the matter on 23rd, 22nd.
Not 22nd inconvenient. 23rd is fine. 23rd or 21st is also fine, my lord.
Yes, 23rd.
Great.
Then number 30, Rupesh Kumar S.
Yes.
Great.
For the petitioner, then. Case.
Already other side is,
They were on caveat, my lord.
but they're not appearing.
Even on the previous date of hearing, they didn't appear.
You know what we can do? Please argue.
In this case, challenge
Where is the impugned order?
Impugned order is at page number 24, my lord. The operative portion of the order. $25,000, my lord.
Accordingly, the respondent is directed to pay a sum of rupees 25,000 per month to petitioner towards the interim maintenance, filing so and so till the disposal of the case. How much they sought?
Hello?
They sought, how much maintenance is sought?
The maintenance is sought 50,000, my lord. Is the
You are for the wife or husband?
Husband, my lord.
Yes. How much is sought? 50,000.
Yes.
Court had granted 25,000.
25,000.
To the wife and the daughter?
Yes, my lord. Son.
Son. Please come to the reasoning part, we'll see.
No, there is no reasoning as such, my lord. That is
Let's see from
granted,
the-
my lord. It is at
You
the
know, there is a
paragraph number
caption of reasons.
14, my lord.
No,
Paragraph
there is a caption of reasons, whether it is contained or not, read
Yes.
from there.
Yes, my lord. The paragraph number 11, 12 and 13, my lord, where the repetition of facts, my lord. And paragraph 14, my lord, is the reasoning given.
Come to that paragraph.
However, it is an admitted fact that the petitioner number 1 is legally wedded wife of the respondent. The petitioner number 2 is born to the petitioner number 1 out of their wedlock. The allegations made by the respondent in his objection statement is required to be tried.
So what are the grounds?
My lord,
What are the grounds?
no, my lord,
What
the
is your
ground is
salary?
that, my lord,
Your salary?
My lord, in the petition, my lord, came to be filed on.
You said your salary is
No,
1
no.
lakh and odd.
Yes,
1,30,000.
Yes, ma'am. The petition, my lord, came to be filed on 21/11/2024, ma'am.
Hmm.
And there is a document, my lord, at page number 81,
Hmm.
which says that as per our school attendance, page number 81, ma'am. As per our school attendance records, the child is not attending the classes from 14 October 2024, ma'am. Even prior to the filing of the petition, my lord, the respondent herein has not sent the child to the school, ma'am. And that has not been stated in her petition, my lord, either in the petition or in the application filed for maintenance, ma'am. And in the affidavit of assets and liabilities, my lord, she shows that she has been sending the child to school, my lord. And the petitioner herein, my lord, has already deposited the amount, my lord, the school fees to the school, deposited the school fees, my lord.
First of all, it is like that. The court had granted 25,000.
Yes, ma'am.
What is the difficulty in paying it?
My lord, there are allegations of adultery, my lord.
That way, at this stage, we cannot go into
Yes,
that.
I agree, my lord. I agree, my
And your salary is 1,30,000. Court has granted only 25,000.
The respondent, my lord, has also considered the fact that she is working, my lord. That she has not stated anywhere, my lord. In spite of
Where she agreed?
My lord, affidavit is at page number 59, my lord. 59. Assets and liabilities affidavit.
No, can't you pay that much for the daughter and for the child and the wife? Then your salary is, I can understand.
I agree, my lord, but the respondent, my lord, is into multiple affairs, my lord, and for which the petitioner has already filed a divorce petition on the same ground, my lord. And the child, my lord, was kidnapped from the custody of the father, my lord, for which there is a petition complaint, my lord.
You can file a GNWC petition.
That also I have filed, my lord.
Then you can say,
That
placing
also I
all the
filed.
details which you have placed before this court, so to give custody to you, because mother is not taking care of it. Now, as far as this maintenance case is concerned, we cannot look into all that. Here, the court also do not mention about the educational expenses.
That is the reason, my lord.
The court only says about the maintenance of 2 children, looking at your 1,30,000.
My lord, in spite of paying school fees, my lord, the respondent has not been sending the child to school, my lord, simply claiming the
You have
maintenance.
to understand that this court cannot go into this in this case. You have to, you file a JNWC.
Yes, my lord, yes.
In that you can file this application.
Maintenance is claimed for school expense as well, my lord.
How much is the school expense?
My lord, that is already paid. That is not explained, my lord. That I have already paid.
How much, that's what I'm saying, how much is the school fees?
My lord, 40 to 50,000 per month, per year, my lord.
Per annum?
Per annum, yes.
How much it comes to month?
5,000, my lord. And moreover, my lord, she is working, my lord. Even that fact, my lord, she has not disclosed.
Even if it is, she's working.
I agree,
You
my
can
lord.
give
But
that amount for your
But
child.
my lord,
who
she has
is,
to come before the court with clean hands, my lord. She cannot suppress those facts, my lord.
What is the material before the court you placed? Because when you're
But I
saying
had
that she's
placed
working,
chat messages, my lord, which involves that she is working, my lord.
chat messages between whom?
Between her and another person, my lord, with whom she is in relation.
Not in this. We can't do a roving inquiry in a criminal misdemeanors like this.
Well, that is the reason, my lord.
Leave it all these issues open to you to raise at an appropriate time.
But even otherwise, 25,000 is on a higher side, madam. 25,000 is on a higher side. And she is not, my lord, at least the school expenses may be reduced, my lord.
So you
Because she is not sending the child to school, my lord.
20,000 will say.
15,000, my lord. She
Even
is
that
also
5,000,
working, my
now
lord.
that 5,000 is also reduced because they are not appearing.
I agree, my lord. My
For
lord,
reasons
she
for
is
that.
also working, my lord, and she is working as
No
a
material on
event
this.
manager.
As such, all the charge she is having with somebody and how this has to be taken, you should have placed before the trial court.
My lord, I have placed, my lord. All the documents I have placed.
Where is that? Where are the charts?
My lord, I have not placed it, my lord, before the. It is in
Agreed
Kannada,
with
my
orders
lord.
passed in. I number 2 in criminal miscellaneous number 999-4/2024, dated 19 May 2025. The husband is before this court questioning the quantum of maintenance that is granted by the court, that is 25,000 to the daughter and to the daughter or son?
Son, my lord.
To the son and the mother. Learned counsel appearing for the petitioner father submits that the court, without considering the fact that the wife is earning and the fact that in spite of the father paying the school fees, the mother is not sending the child to the school, the court had granted an amount of rupees 25,000, which is on the higher side. Learned counsel has drawn the attention of the court to the school records, which show that the wife is not, the child is not, the boy is not sent to the school regularly. It is submitted that the court, when he has placed before the court the chats between the wife and the other person to show that she is working, court has failed to consider the same. It is submitted the order that is passed by the court is on the amount of maintenance that is granted by the court is on the higher side, and the same needs to be reduced. Next para. Though a caveat is filed, there is no representation on behalf of the respondent. This matter came up before the court on 9/7/2025. On that day, the counsel for the petitioner is present and there is no representation on behalf of the respondent caveator and directed the matter to be listed on 15/7/2025. Today also when the matter came up, there is no representation on behalf of both the part, on behalf of the respondent.
It is in Kannada, my lord.
Today also there is no representation on behalf of the respondent caveator, and hence this court deems it appropriate to pass the final orders as sufficient opportunity is given to the respondent. Next para. Having heard the counsels on either side, counsel for the petitioner, there is a material on record. The wife had filed the petition seeking maintenance of an amount of rupees 50,000. The admitted facts are that there is no dispute with regard to the relationship, and the husband is earning 1,30,000. According to the husband, the wife is also earning. For that, he is relying on a chat between the wife and some other person. And apart from that, there is no other evidence on record. And his case is that the wife is not sending the child to the school. It is also undisputed that already a JNWC is filed seeking custody. Any of the reason, any of the things that are relating to the child can be brought to the notice of the court, and it can be brought to the notice of the court that the welfare of the child is not in being with the custody of the mother. Those issues this court cannot go into. When the salary of the petitioner is 1,30,000, when the court had awarded an amount of rupees 25,000, this court do not find any reasons to say how it is on the higher side. However, considering the fact that in spite of spending an amount of rupees 40,000 towards the school fees, the mother is not sending the boy to the school, and no other material is placed before the court, is not sending the school, and the mother has not chosen to come before the court and explain whether whether the case of the husband is correct or not. In those circumstances, this court is inclined to modify the order passed by the family court, and the maintenance of 25,000 is reduced to 20,000.
15,000.
And all other contentions are open for the husband to raise before the court, or before the appropriate court at an appropriate time. Yes, by way of a petition. Yes, next. 31.
Sale number 31.
Petitioner, my lord. The impugned order is page number 25, my lord. We permitted to read page number 27, para number 2, my lord. My grievance. Yes, page number 27, my lord. 27, para number 2. My only grievance is that the urged by respondent is that since he led the marital life.
27, paragraph number
2.
Please read.
The only grievance urged by the respondent is that since he led the marital life with the petitioner number 1 from 15/11/2012 till 10/7/2019, and he consistently provided all the basic needs to the petitioners, he during the said period has no obligations to pay the maintenance to the petitioner. So what happened, my lord? The execution court has issued 15/4/25 FLW. So our only contention is that she has stayed with us for from the period from 2012 to 2019. So
when is the order? That's what I was repeatedly asking you yesterday. When an order is passed, when you feel that in that order this particular aspect is not considered, you have to seek modification of that order. That order has become final.
Yes,
so
madam.
Executing court cannot go behind that order and pass any other order.
Sir, full submission is that I can be liberty to seek clarification before the trial court.
When is this order passed?
So this judgment is passed on 21st October 21, my lord.
So now why should I give the liberty for you for modification? We cannot.
No.
Because that's for you. If the law permits, I'll say, if the law permits, you can seek. I cannot give. Why should after from 21 till 25 you keep quiet?
The respondent is staying with me only, my lord, residing with me only, and I have paid monthly 5,000, and they were taken a contention of that paying 5,000 to the MC case.
By the order passed agreed with the order dated
2/4/2025.
2025, whereby the court has directed the petitioner to pay the maintenance as per the order dated 21/10/2021, passed in criminal miscellaneous number 641 of 2011. An order was passed on 21/10/2021, whereby the petitioner was directed to pay the maintenance to the respondent wife. When the order is not complied with, she has filed the execution petition. In the execution petition, the court has passed this order directing the husband to pay the amount. The court has directed to reissue FLW to the respondent if PF is paid. Land counsel appearing for the petitioner submits that the wife has stayed with him from 15/11/2012 till 10/7/2019, and he consistently provide all the basic needs to the wife. during the said period, he has no obligation to pay the maintenance to the petitioner. This court has perused the order and heard the counsel for the petitioner. An order is passed on 21/10/2021 directing the husband to pay the maintenance. If it is his case that between 5/15/11/2012 till 10/7/2019, the wife is with him and he is not supposed to pay the maintenance, he ought to have questioned the order dated 21/10/2021. In this case, the petitioner has not chosen to question the said order, and the order dated 21/10/2021 has attained finality. Now, in the executive, before the executing court, the petitioner cannot raise the said ground, and the court, the trial court, the executing court has rightly asked the petitioner herein to pay the amount, and if the PF is paid, to issue the FLW. This court do not find any reasons to interfere with the order passed by the executing court. However, land counsel appearing for the respondent submits that they may be given liberty to question the order dated 21/10/2021. If the law permits, the petition is at liberty to seek the petition. If the law permits, so he can seek clarification, and this court is not granting passing any order in that regard. Accordingly, the petition is disposed of. Next.
32. Dhanlakshmi Bai.
Yes.
For the petitioner, my lord. My lord, there's another matter pending which is arising out of the same impugned order, my lord. It
Just
may be
along with
connected.
so and so, take the number. When do you want?
Any date may be fixed, my lord.
This is a matter on 25th. Yes, next.
Obliged, my lord.
Cell number 33.
Waiting for petitioner.
Senior counsel is appearing. Senior.
I appear on video.
Yes, Mr.
Yes. This is a case where the husband has sought for quashing the proceedings initiated by the respondent. I would be requesting your lordship's kind attention to page number 1. For the reason that she has filed and has been filed in a synopsis. Marriage, I'm sorry.
No, before that, we'll go to your prayer.
No, my prayer in the present
By
petition
the
is
respondent in MC number dated on the file of the so and so. Why should this court quash the proceedings? Exercising the jurisdiction of 227?
yes, that is the reason why, my lord, I am first referring to page number 1 for a moment. I would be, marriage takes place on 17/1 only to harassment rather than to make extortion. 17/1/21, my lords, see, marriage takes place on 29/5/23. She files petition for the dissolution of marriage. Thereafter, my lord, within 3 months, she files a petition for claiming maintenance of rupees 1 lakh from me per month. Assuming that the claim was justifiable and justified, kindly see the next one. 24/11/23, she files a domestic violence petition in which she makes a claim of a modest sum of rupees 25 lakhs maintenance per month. 25 lakhs and 5 crores as permanent alimony and 48 lakhs as marriage expenses. So, not being satisfied with all these 3 petitions she filed, kindly turn to next one. 29/12/23, she files a dowry harassment case against me, and mother, a charge sheet has been filed against me, but charge sheet has not been charges have not been framed. This is a position. Now, mother, the question very rightly asked by your lordship is, normally this honorable court would not interfere when mother, a petition is pending and I have already filed a statement of objection. Only yes. To page number 37. That is the original petition, in which
yes,
she had prayed only for a dissolution of the marriage. may read the dissolutionary marriage which took place on 17/1/21. Of course, I have really no objections for the dissolution for the reason.
Yes.
But having not claimed any other relief than dissolution of marriage, she files a petition for maintenance as already submitted, claiming 1 lakh maintenance per month, that is 3 months later. Even assuming that is correct, I would be requesting your lordship to kindly page 45, mother. After that, I filed my statement of objections in the dissolution petition. She files an amended petition. And in the amended petition, she makes a claim. I will request your lordships kindly to see the prayer. Wherefore it
She is
is
seeking
prayed.
5 crores.
Page number 45, last paragraph. Prayer portion.
I've seen
May I
that.
read?
I've seen that. She's seeking 5
Yes.
crores.
And a sum of rupees 5 crores and pass. So she claims 5 crores as maintenance. So having filed a petition for 1 lakh per month separately and 25 lakhs maintenance also claimed. Therefore, how many petitions I should face? Therefore, I am asking, now this matter is at the stage of cross-examination of the respondent.
Now, if on the reasons which you are submitting, if the petition has to be closed, all matrimonial proceedings have to be quashed, because every matrimonial proceeding will have these many complaints.
The other prayers cannot.
Under 227, how can we interfere with all that? There is if a petition is filed, if it is, if that has to be rejected, there is a provision before the family court. You have to file an appropriate application, or else it is under some other act. But under 227, why will the court quash the proceedings just like that? Something is, you're not audible.
Sir, your voice is not audible to the court, sir.
ಅವ್ರಿಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Hello. May Miller? Am I now audible, Miller?
You're audible now.
Yes, sorry. Miller, as far as dissolution of marriage is concerned, Miller, it is just like the patient asking for milk and rice. The doctor also prescribing. I am also not interested in continuing the strained marital relationship. Therefore, dissolution may be granted. But I respectfully request your lordship to see that the petition for amendment having been allowed. Now, she claims.
No, Mr. Senior Counsel, you have to please tell the court, under 227, how can this court quash an MC that is filed, or partly quash an MC, partly allow an MC that's filed for divorce, and quash as far as the maintenance is concerned? What is the jurisdiction of the court to do this? Which law provides?
Yes, I agree with that. I have also method difficulty in answering this question, because I am only on one aspect. How many petitions can be filed for the same relief, Miller, by the same party?
Now, the court is also saying, if this question is asked by every litigant, then every matter has to be dismissed. Every MC has to be quashed by the High Court. That's how the marital relation, that's how the cases are. You cannot help
But
it.
in fact, the petition, Miller, should have been for partly quashing the second prayer, that is the maintenance prayer, which is not to be maintained in the present petition. One divorce may go on. Therefore, to that extent, your lordship.
Your lordship, subject to my land senior counsel, I want to submit, my lord. There is a PCR has been filed, which is referred to the police station for investigation, my lord.
At least it is the senior counsel is arguing.
But till
Please understand.
please, madam.
Because the senior counsel is arguing.
Please, madam.
To respect him, I heard. If
Please,
you
madam.
argue, I will not even hear one of
No, madam.
and I'll dismiss it with cause.
I'm not that, my lord.
I'll dismiss it with cause, even if
No.
you submit one word more. The petition, the present petition is filed, taking the following prayer, extract the prayer. Then the senior counsel appearing for the petitioner submits that the marriage has taken place on 17/1/2021, and the wife had filed the MC on 29/5/2023. That's MC number 482 of 2023 for the family court at Mysore, seeking divorce. Initially, she sought for divorce, and thereafter she has amended the prayer and sought for the alimony of an amount of rupees 5 crores. Thereafter, on 29/8/2023, she has filed criminal miscellaneous number of seeking maintenance. On 24/11/2023, she has filed a petition under the Domestic Violence Act under section Domestic Violence Act, that is numbered as criminal miscellaneous number 96 of 2023. Then a complaint is registered on 29/12/2023 for the under the as on the for harassment. That's crime number 212 of 2023, and the charge sheet is filed in CC number 229 of 2024. Then on 3/5/2025, the husband had filed a complaint against the wife and others for the illegal relationship with many persons, along with proofs such as videos, photos, audio clippings, emails, WhatsApp chat, along with other proofs in PCR number 5021 of 2025 on the file of the 24th ACMM, Bangalore, which is now registered in crime number 218 of 2025 by the 2025 Kamaksha Palya Police for the offences under section 84, 88, 115, 118, 119, 131, 216, 238, 248, 329, 351, 352, and 35 of the BNS Act 2023. It is submitted by the senior counsel that it is nothing but a pure abuse of process of law. And in fact, the husband also wants the divorce, but as far as that claiming exorbitant amounts under different by filing different applications is a pure abuse of process, and the same has as such this court has to interfere with the same and quash the relief as far as the claiming of an amount of rupees 5 crores is concerned. Next paragraph. This court has heard the senior counsel appearing for the petitioner and also perused the material on record. On the first and the foremost, the relief as prayed for by the petitioner seeking to quash the MC because it's a frivolous petition by this court while exercising the jurisdiction under Article 227 of the Constitution of India is itself not maintainable. When a petition is filed before the court at a stage, the court cannot under 227, the court will not. Court is not exercising the jurisdiction under 482, where the court decide that whether it is an abuse of process or any complaint is filed without any basis, or it has to be quashed. If the plaint has to be, if a petition is filed, if it has to be rejected, there is a procedure contemplated under the CPC and under the provisions of TPC. If the petitioner has any remedy, he has to go before the trial court. Whatsoever are the reasons, this court cannot decide that a particular petition is a frivolous petition. In those circumstances, if the relief that is sought by the petitioner cannot be granted, accordingly dismissed.
One request, your lordship may kindly say liberty is reserved to approach the trial court for the relief.
No, I said you have if you have the remedy, if the petitioner has any other provision of law permits him to seek such a relief, it is for the petitioner to avail the said relief. Yes. Next.
Number 34, Siddaramaiah VP.
Yes.
Petitioner is husband. Respondent number 1 is wife and respondent number 2 is daughter. Respondent number 1 wife is a BE.
1,000 and 2,000 is granted.
Well, as far as daughter is concerned, child is concerned, I have no.
What is your income?
His income. The reason, as far as the wife is child is concerned, I am not challenging.
First of all, tell the court what is your income.
Income, my lord, it is not disclosed. The reason. No,
Not telling what is the income. We cannot reduce the maintenance.
My lord, my aspect is.
Income is 80,000 per month.
No, his income is disclosed as 49,000. Sorry, respondent salary is disclosed, my lord. At page number 28, his drawing salary of 49,000. page number 20, 49,411.
49,000?
411.
Hmm.
Whether the grievance of the petitioner is, the respondent number 1 is a BE Electronics and MTech graduate, and she is running the charts and juice center. We have produced the medical documents from starting from page number 52.
Please come to the reasoning part where the court had discussed with regard to this.
Page number 44, ma'am.
Yes, please read.
Discussion is to start from para number 18. And as far as earning is concerned, at para number 19 it is discussed, ma'am.
Fifty-seven thousand two eighty,
Yes.
and after deductions, it is 49,411.
Yes. And as far as my grievance is concerned, page number, para number 19, it has been discussed. And respondent number 1 is.
One minute.
Yes, please, ma'am. She is qualified and BE and MTech graduate. Earlier she was working as a software engineer. Now also she is working from the home. And she is also running a juice center, juice and chat center.
Then the 2,000 that is granted to the son is very low. We'll make that 6,000 to the child.
Well, the child.
What is the age of the child?
Child is 1 year, 1.5 years, 2 years roughly. As far as the child is concerned, let it be written, 6,050% stay may kindly be granted for the wife. She is a MTech graduate and she is gainfully employed, and she is also doing
So
business.
let's see how the court has dealt with it.
Please, ma'am. The other matters are with respect, it needs some evidence. So
No, at
evidence
this
needs to
stage
be
you
established,
pay-
my lord, as far
at
as the
this stage you pay
prima
when you-
facie, I have made out a case that the respondent number 1
Prima
is.
facie she has also made out.
Please, my lord. Respondent number 1 is gainfully
Please
employed.
read paragraph page number 16 from the as noticed above. Please read.
Yes. As noticed above, petition number 1 in her affidavit or asset liabilities has shown her occupation and income as nil. That may not be correct, my lord. The respondent in support of his contention has produced a rest copy of QR code, scanner and photos to show the petition number 1 is running juice shop. It is pertinent to note that QR code and photos produced by us does not disclose that the juice center depicts the said photos, and QR code scanner belongs to the petition number 1. The respondent at this stage has not placed cogent material to show that the juice center and the chat center depicts in the photo and QR code. Scanner belongs to the petition number 1. On the basis of the documents laid by the respondent, photos and Xerox copy of QR code, it is difficult to hold the petition number 1 is running juice center earning from the same. The phone number, my lord, which is shown in the QR code is the same phone number of the petitioner. Admittedly, respondent number working in ACE designer so-and-so, Pinya, Bangalore, and drawing salary contains no respondent is raised loan from Ramakrishna and for Access Bank, and he is discharging the said loan, and he has to look after his aged ailing parents. Respondent in the affidavit assets and liabilities has shown some liabilities. No doubt it is true that respondents take care of his aged parents and to discharge his liabilities. At the same time, respondent being husband of the petition number 1, father of the petition number 2, it is his burden and moral obligation to maintain the petitioners. Therefore, respondent cannot escape from his liability maintaining petitioners. At this, the respondent does not produce any cogent material to show that the petitioner earning more than rupees.
How this court can take a different view from that of the trial court by granting a stay now?
My lord, as far as the documents is concerned, my lord, photographs are also shown. As she is running the, she is in the shop premises. Those produced are
seen in the photograph.
Yes. And also the phone number which is shown in the QR code belongs to the phone
That's
number.
what, there is a finding on that by the court with regard to the QR code.
Yes. QR code is concerned, there is a finding as far as the phone number is concerned.
Xerox of the QR scanner and photos to show running juice shop.
As far as
Even assuming that she is running a running some business. What is the amount she is deriving from that, earning from that?
And also she is qualified, my lord, BE Electronics and MTech graduate.
That can be finally decided by the court in a full after a full-fledged inquiry. At this stage, this 6,000 and 2,000 is a very nominal amount court has.
But as far as 2,000 is concerned, my lord, it may be retained. As far as the
1,000 also, it's waste of time to keep this petition pending. No purpose will be served. But the present petition is filed, agreed by the orders passed on my number 2 in criminal miscellaneous number 249 of 2024 dated 29 January 2025, whereby the court had granted maintenance of an amount of rupees 6,000 to the wife and 2,000 to the 2,000 to the child. It is a case of the wife that husband is working at accounts department at ACE Designers Penna, second stage, Bangalore, and deriving an income of rupees 80,000 per month. It is the case of the wife. It is the case of the husband.
Let me make one for submission. At page number 63 for prima facie.
Number?
63. For prima facie, these are all the documents which are produced before the trial court. We have produced the sufficient documents and the photographs that has been suppressed by the respondent.
Let the court conduct further inquiry. At rupees 80,000 per month. 80,000 per month. It's a case of the husband that is drawing salary of rupees 57,208, and after deduction is drawing net salary of an amount of rupees 49,411 per month. It is a case of the husband that the wife is running a juice shop, and she is
Juice and Cat Center.
And also
Juice and Cat Center. CH-18 Chat Center.
CH-18 chat, yes. Juice and Chat Center, and earning more than Juice and Chat Center with the photos you have placed before the court, 1 lakh per month.
Yes.
Some reasonable, at least when you are saying that, you should have said some reasonable amount, and earning more than rupees 1 lakh per month. And in that support, he has shown
and 1 lakh is not from only Chat Center. It is from, she is a software engineer and she is working from home and also from the both business. She is
and he has relied on the QR code. The court has given a finding that the husband has not placed cogent material to show that the Juice Center and Chat Center depicted in the photos and QR code scanner belongs to the wife. On the basis of the documents relied upon by the respondent, that is the photos and the Xerox copies of the QR code, it is difficult to hold that the wife is running Juice Center and earning from the same. The court has come to the conclusion that at this stage, basing on the material on record, that the husband is earning an amount of rupees 49,411. That's a take-home salary. The husband is liable to pay the maintenance of an amount of 6,000 to the wife and 2,000 to the child. Next para. Land counsel appearing to the petitioner has submitted that the wife is she's a what is BE graduate or ME graduate?
BE Electronics and Communication and MTech graduate.
She's a she's an MTech graduate.
MTech graduate.
She's an MTech graduate, and she is working from home and earning apart from the Juice and Chat Center she's running, and also she's having income from that, and according to him she is earning 1 lakh. And the court, without considering the material that is placed by the husband, had granted the maintenance. He submits that he has no objection to pay the maintenance to the wife, to the daughter, but not to the wife who is sufficiently earning. Next para, having other than counsel the petitioner for his material on record. The court has granted 6,000 and 2,000, that's 8,000 per month. And the salary of the husband is 49,411. That is after deductions, it is a take-home salary. He is relying on certain documents to show that she is earning, and it is a case of the wife that she is not earning. The court has given a finding that at this stage, the court cannot consider all those, looking at those documents, the court cannot come to any conclusion to say that the wife is earning and had granted the maintenance. This court is of the view that the reasoning that is given by the court, that at this stage, basing on what has been placed before the court cannot say that the wife is earning and she is not entitled for maintenance. In the due course, if the sufficient material is placed before the court, the court would be in a position to consider the case of the petitioner. And whereas, as far as the interim application is concerned, the court has passed a reasoned order and all the contentions are open to the petitioner while the main petition is considered. He can address the arguments accordingly. This court do not find any reasons to interfere. Dismiss. Yes, next.
35.
For early disposal, my lord. Early disposal of the petition.
Which year is the criminal miscellaneous?
That year of the 24.
Which court?
Tumkur Principal Judge Family Court.
The other day you sought for the data. 2024, there can't be a direction.
Yes,
Yes.
ma'am. Yes.
Yes, next.
Cell number 35.
Petitioner.
G. Ravishankar Shastri.
Yes. What is the impugned order?
There are two impugned orders, my lord, I have called in question. One is rejection of my application, my lord, to production of the CCTV footage by the bank authorities, my lord. The second one is directing the, my lord, petitioner to pay educational expenses of the respondent number 2. These are the.
Petitioner is the husband.
Petitioner is the husband, my lord.
It's arising out of criminal miscellaneous.
Please, my lord. Wife and my lord, major son now.
Oh, why that CCTV footage in a criminal miscellaneous evidence?
My lord, my defense was that, my lord.
Because you appear in civil matters.
No, my lord. My lord.
Come to the impugned order.
Very interesting aspect, my lord. Husband gives his ATM card to the wife, my lord. And quarters of the husband was also given to the wife. She resided therein along with the son. My lord, husband was made to reside in a staff, my lord, restroom. He was a, my lord, bus conductor. Now, my lord, he is doing the same job, my lord, in the KSRTC department. Then, my lord, when there was a dispute, my lord, husband gives his ATM card to the wife, my lord, for her maintenance. She withdraws 20,000 per month every month, my lord. That is my specific defense. And I state that I have not failed to maintain her nor neglected to maintain the wife, my lord. This is my specific defense.
No, you were referring to something which has happened. No, yes. We are only in an interlocutory application. At present, what is happening?
No, now during my evidence, I make this present application stating that, my lord.
When is the petition filed for the criminal miscellaneous is filed when?
That is, my lord, on 1/6/24.
1/6/2024.
Yes.
According to you, till when she was withdrawing the amount?
My lord, my defense was that from 1/1/2015 till 30/6/2023.
36/2023.
2023.
So now she will be seeking maintenance from 1/6/2024.
Yes.
Where is the question of looking at all that now? And how is it? I mean, concerned with this case?
That is, my lord, the precisely learned family court holds, my lord. But my lord,
there is the order. That is the one point is gone. What is the next one?
Yes, next point, my lord, a major son, my lord, till my lord, his PUC education, my lord, I have given all the facilities.
What is his age now?
Now, my lord, he crossed 18 years, my lord. His date of birth was 13/6/2006, and as on 13/6/2024, my lord, he attains the majority. 13/6/2024.
As on the day when the application is filed.
No, my lord, he was 13 years, 13 days.
Less than 1/6, it was on 1/6.
Yes, my lord.
So what is the finding of the court on that?
The court holds that, my lord, there is a requirement to pay the college fees of
come to that order.
Please. That is at page 20, my lord. Para 7, my lord.
Read from para 7.
Yes. The petitioner is seeking interim order for relief of payment of respondent towards education fees. Earlier to this application, there was no any application filed for interim maintenance. There is a specific provision in section 125 proviso which provides for granting of any interim maintenance to the wife or such a child, the expenses which magistrate considers reasonable from time to time and directs such person to pay the same. Hence, as per the above provision, It is not specifically regarding any payment of maintenance as provided in section 125 subclause 1 and A to D. Only on merits of the case and for passing final order, the contention taken by the respondent in the present objection of the application can be considered. But petitioner has filed this interim application during the pendency of the proceedings, and the court can, without going to any other
So
contention.
where is your case? Where are your objections with that? He is already a major and I don't have to pay the maintenance.
That is the, my lord,
Where is that? Where is
my
it recorded?
objections, my lord, Lorships get it at para 9, my lord, annexure G.
So why now there are two IAs? Why can't there be two writ petitions for the two IAs?
Different court fee paid, my lord, and common writ petition was paid.
Instead of that, anyway, you're paying the court fees. If you
Yes.
file two different writ petitions, like that's what we do in even in civil matters also. That's how it is done. No, it's a difficulty. If two petitions, writ petition is pending, you are seeking now two applications. Now one application, I say it is not maintainable. One application is maintainable. So it's and again the writ petition is pending here.
Yes.
Then what? Where is the second order?
That is where, my lord, second order I have read regarding
Where is-
payment of education.
No, not education. The first order.
First order, my lord, get it page 14 onwards. My lord. Page 15, my lord, gets in the middle portion.
The present writ petition is filed, agreed by the order dated 2/5/2025, which is filed under section 94 of the BNSS. And the other is dated 14/5/2025 on an application filed under section 125 CRPC seeking where the court had granted educational expenses of the child. The first order is with regard to
2/5/25, my lord.
the first order, that is no IA application number,
No application.
where the application filed by the uh, husband under section 94 of BNSS, whereby he sought for he wanted to produce the CCTV footage
Through
but the-
manager of the bank.
Huh?
Through manager of the bank, my lord.
CCTV footage through the manager of the bank to show that the wife was withdrawing 20,000 per month and the husband has been taking care of the needs of the wife. The court by order impugned had dismissed the said application, observing that fact of payment of earlier amount from 1/1/2015 to 36/2023, and in that regard he wants to place a CCTV footage. It is unconnected to the present case. The application is filed seeking maintenance on 1/1/2024.
1/6/2024.
1/6/2024, and and even if this application is allowed, no useful purpose would be served, and the court had dismissed the petition. As far as this relief that is sought by the petitioner is concerned, the order that is passed by the court is a well-considered order and no interference is called for. Then coming to the second prayer, it is the contention that the petitioner, that the respondent is a major son, and the application is filed, the petition is filed seeking maintenance on 1/6/2024 and he attained majority on 13/6/2024. The court had not considered the such fact that the major son is not entitled for maintenance under section 125 CRPC. Considering the same, there shall be stay of all further proceedings pursuant to the order dated 14/5/2025.
Please.
Please confirm that
14/5/2025.
2025, where the court had granted maintenance to
My lord,
the son,
educational expenses.
educational expenses to the son. Notice to the respondent.
Please.
This is a petitioner is permitted to take out hand summons and shall file a memo to that effect. This is a matter on 5th of August. By the time if the memo is not filed, the stay granted by this court stands vacated. Yes.
Please.
Bill number 36 for admission
In all
matter.
this notice from the court, in addition this. Yes,
Bill number 36, Manjunatha P for petitioner,
Husband petition.
Sandesh P, Nadiger,
Husband petition, madam. Modification of the maintenance.
how much was granted?
20,000 rupees granted, my lord.
20,000. What is the salary?
15,000 to wife,
And
5,000 to daughter.
15 plus 5.
20.
What is the salary of the husband?
73,000. As on the date of filing the petition, 73,000. As on the date of passing the judgment, my lord, 1,01,000.
Then what is the difficulty?
Please.
What is the difficulty to pay the amount? Difficulty to pay the amount. Why he is before this court? On what ground? No ground. Please come. Agreed with the orders passed in criminal miscellaneous 16 of 2020, dated 24th March 2023, whereby the court had granted maintenance of an amount of rupees 15,000 to the wife and 5,000 to the daughter.
Please.
5,000 to the daughter. The husband is before this court. The parties are referred to as wife and husband for the sake of convenience. The wife had filed the petition seeking maintenance of an amount of rupees. How much? How much is sought? 60,000 per month. And 30 each, 30 has sought for 60,000. That is 30,000 each to for the daughter and her herself. The court had granted 15,000 and 5,000, and while granting the same, the court has observed that
25, page number, para number 20.
that the husband is working as a manager in Mahindra Aerospace Private Limited at Bangalore and getting salary of 73,924 per month. And the father of the husband is retired ASI getting monthly pension. And the court also observed that wife in her statement of assets and liabilities disclosed the educational expenses of the daughter at 15,000, but she has not produced any piece of document like school receipts, etc., to know how much of amount she requires towards educational expenses of the daughter. The court, considering the avocation of the husband and the income of 73,000, had granted 15,000 and 5,000. Next part. Then counsel appearing for the husband submits that the court, without considering the expenses and the assets and liabilities that are filed by the wife and the husband, has granted the amount. It is submitted that the amount of maintenance that is granted by the court is on the higher side. Then counsel appearing for the respondent submits that as on the day when the petition is filed, the income of the husband is 73,000. Now it is increased to 1,50,000.
Please.
1,50,000 now.
1,01,000.
Now it is increased to.
As on the date of passing the judgment.
As of the date of passing of the judgment, the salary of the husband is 1,01,000. It is submitted that when the wife. His submissions I'm saying.
Please.
It is submitted that when the husband is in a position to pay the maintenance, and when it is the bounden duty of the husband to take care of the wife and the daughter, without any basis, this present application is filed. Next para, considering the submissions of both the parties. Produce the material on record. The amount that is sought is 60,000, that is 30,000 each. And the court had granted 15,000 to the wife and 5,000 to the daughter. Income is 73,000, and even without even considering that his salary is enhanced to 1,05,000, Even at 73,000 also, there cannot be any difficulty for the husband to pay the said amount. In the considered opinion of the court had rightly granted the maintenance, and this court finds no reasons to interpret.
Please.
Next.
Bill number 37, Venkatesh R. Bhagat for petitioner Megal Mane Prabhu.
Husband's petition. Rupees 10,000 is awarded to wife and 5,000 to the son. I'm not disputing the
What is
payment.
that? 50? How much?
10,000 to wife, 5,000 to son. I'm not challenging the maintenance awarded to son, only on three grounds, my lord. First, I filed a petition for restitution of conjugal right under section 9. Order was passed. She has not come. Then I filed a petition for divorce on the ground of very same ground. Divorce was granted. She has not come.
This is granted under 125.
Yes, madam.
This is granted under 125.
Yes, madam.
How a wife who has deserted the husband, no restitution. Now, he has filed for restitution of conjugal rights. An order is passed.
Yes.
What happened to that? Have you questioned it? So, the findings of the court that without a reasonable cause, you are staying away from the husband is attained penalty. Have you contested the matter? Have you contested that MC? It's an ex parte decree. It's an ex parte decree.
She is not coming. Nowhere she is coming. Yeah. Then MC
Then
also.
Divorce proceedings also she didn't come.
Advocate was engaged, but nothing has been done and divorce granted. And that was produced before this court, my lord. And asked a specific question: have you challenged it? No, she said, I'm not challenging, but I want money.
Take whatever. What is their citation? No. Divorced wife is not entitled for maintenance. That's not. Even if he's saying we will not consider further.
I am not telling that.
She is entitled.
Yes.
No, a wife who has deserted the husband willfully is not entitled for maintenance. That's what 120. Read 125 CRPC.
One is conjugal decree of the conjugal rights is not aware of the wife, and also divorce wife she is not independent. Husband is not successful. Wife is having a income.
No, but what you have to understand is when he has filed a petition for restitution, he says the wife is without a reasonable cause is staying away from the matrimonial home. Court, your notice is served, you don't appear, and the court passed an ex parte decree saying that without a reasonable cause you are staying away, please join the husband. So now all these grounds about adultery and all, nowhere you have raised, that is one part. Then the divorce proceedings. Because restitution is not honored, that order decree passed by the court, he files for divorce. There also you don't contest. Now under 125 CRPC, what is the ground that you are staying away from the husband without a reasonable cause? I can understand if the decree of divorce is granted on some other ground. Who will tell that? Will this court decide in this? You have to contest the restitution, or if the restitution order is passed, you have to prefer an appeal, or you have to contest the divorce decree. There you can tell the court. The court would have not granted the divorce. All keeping quiet, not pursuing anything, and you file 125 CRPC proceedings and seek maintenance. Yes, please come, please. Yes. Paragraph number. You are given the running page numbers. What is the page number? 13. Huh? 13 is saying. You are reading 3-3 or 1-3?
3-3, my lord. Para 38
Yes.
of second judgment.
Hmm. Give 125 here. 125. Yes. CRPC. Hmm.
125 here.
You have filed the divorce on what ground?
She has not come, and cruelty, both. She filed a FIR against
She
me.
sought for desertion also.
Yeah, both.
So what is the question before the court is, will a husband who secures a decree of restitution of conjugal rights stand absolved of paying maintenance to his wife by virtue of section 124 of the so-and-so, abide by the said decree and return to the matrimonial home? Then this is answered at paragraph number? Paragraph number? Please read. Where is this Rohtas Singh versus Ramendri and others? 26. That is 2003 SCC 180. Take that. 2003 SCC 180. 180.
It says, page 3, it's there, madam.
Page number?
Running page 3.
Running page.
First judgment.
No, not required, Anita. Yes. Let's read this. What do you say on this?
Yes, madam. Madam, in this case, she has to express her desire to join the matrimonial home. In MC case, specific observation was made.
No. No, as per this judgment, the
Yeah, that
distinction
judgment is
is,
regarded after divorce, wife is having right, my lord. I'm not disputing that aspect at all. Now here,
is this granted
yes, my lord.
when during the subsistence of the marriage?
What, my lord?
The maintenance is granted during the subsistence of the marriage, not as a divorced wife.
Interim maintenance was granted. After that, I filed for a specific.
No, the present order impugned is,
a final order, my lord.
it's a final order.
Yes, ma'am.
As on the day the final order is passed, she is a divorced wife,
Yes.
or marriage is subsisting.
No, marriage is not subsisting.
She's a divorced wife.
Divorced wife. Yes.
Court has considered it as a divorced wife.
Yes, ma'am.
No, in the light of this judgment at paragraph 11,
yes,
it is very clear that still, now what the Supreme Court has taken a distinction that 125(4) will come into play during the subsistence of the marriage. When you have to, when you're looking at a divorced wife, then that cannot
What
be
I'm
a
telling you,
ground.
divorced wife, right, my lord. I'm telling you, the divorced wife you have a right to seek maintenance. Now, what I'm telling
No,
you,
no, not she has the right to seek maintenance.
yes, ma'am.
This desertion and all
Yes,
will apply
yes, ma'am.
to the wife who, when she is in relationship.
Yes,
when the marital ties are in contact.
Yes, ma'am. Now here, my lord, willful desertion based on which a decree of divorce was granted. Still, she is
That
entitled.
is also considered in this judgment in this.
But my lord, in this same judgment, my lord, para 18, page 18, maybe kindly seen.
Para 18.
Page 18 of that compilation submitted.
No, more than this judgment. This judgment is very clear on the aspect.
Yes, this is latest judgment, 2025 judgment, where verified
No,
all
it is
these.
only extracted, but there is a 2003 SEC case.
That has been reiterated here,
Correct,
and
but
all.
when the judgment itself is here, why can't we read this?
Yes, ma'am. Yes, ma'am. I will read. Just I will take a lordship to para 18, and I will come back to 2003, my lord. When that is, my lord. Abhinav Muhammad Khoja versus Muhammad Ali, Ramjan Ali Khoja, and others. Bombay High Court noted that an order of maintenance can always be passed in favor of a wife, even her husband obtained a decree of restitution of conjugal rights, unless it is established that she is willfully deserted her husband and was not willing to stay with him without reasonable cause or sufficient reason. On facts, it is found that record it did not show that wife had deserted the husband and was willing to stay with him without reasonable cause or sufficient reason. It was further noted that after obtaining the
It
decree
is an
of
extraction judgment of the Bombay High Court.
yes, madam, but that has been upheld by referred and said she shall say that I'm having a
We'll
cause.
continue after lunch.
Yes.
Yes.
ಎಲ್ಲ ಕಳ್ಸ್ಬಿಡಿ ಲಂಚ್
days ಅಷ್ಟೇ Passwords. No, passwords will complete.
Passover matters, cell number 9.
$50?
Objects.
I'll hear it.
Passover matters, cell number 9.
Serial number? You are for the respondent. Morning counsel for the petitioner was there. I think he asked for adjournment. This is complaints of office objections raised on statement of objections. Then do it. The learned counsel for the respondent shall comply with the office objections. No. 9 is on that now. How that's how it is listed before the court.
Okay.
It's listed before the court only on that ground. First you do it. I'll ask this matter to be listed. Then whatever your objections are, we'll hear. Office objection shall be complied with by the learned counsel the respondent within a week. Week, or if you want before also I can give. A week's time immediately after complying with the office objections. This is a matter. Next.
Cell number 20. Cell number 20.
It can be nothing to submit. Heard reserved.
Now, should I place this judgment because it was not there in the?
Place it. Take it.
And this
Yes.
also.
Cell number 25. Cell number 25. No. Appearing to the petitioner.
Yes.
My lord, the petitioner before this honorable court is here challenging the order of the IA.
I'm sorry. You can.
Challenging the order of the IA. Rejection of the IA filed under Order 7 Rule 11D. On the IA, my lord, was filed on the grounds of res judicata. The brief facts which are relevant only with respect to this matrix.
Before going to the brief facts, I would like to see the order. Where is the order?
My lord, the order begins at page number 154. My lord, I'm sorry, the reasons begin at page number 154.
Please read.
May I read? I start from the reasons. It is an admitted fact that the respondent filed the petition under
Respondent
section.
is who?
Respondent is the
husband or wife?
No, the respondent. This petition has been filed by the wife. I mean, the MC number 4514.
I'm asking.
Respondent is husband.
In this
Here.
Yes.
This reference respondent is husband.
Yes.
It is an admitted fact that the respondent filed petition under section 9 of the Hindu Marriage Act for restitution. My lord, here
yes,
it is actually the petitioner who has filed the.
Please refer to them as wife and husband so that the court
Yes,
will
yes, my
understand
lord.
it.
It is an admitted fact that
MC number 4514 of 2021 is filed by the wife or husband.
MC number 4514 has been filed by the wife.
You're representing wife.
I am representing the husband. So the respondent has filed petition under section 9. It is right. I got confused for a minute, my lord. It is an admitted fact that the respondent filed the petition under section 9 of the Hindu Marriage Act for restitution of conjugal rights before the additional principal judge family court, Gautam Budh Nagar, on 10/4/2019 in petition number 318 of 2019. It is also an admitted fact that ex parte decree of restitution of conjugal rights was passed in the said petition on 21/2021, directing the petitioner to join the respondent within 30 days and to restore conjugal relationship. The petitioner came up with this petition on 6/9/2021 under section 13(1)(1)(a) and 13(2)(2) of the Hindu Marriage Act, seeking dissolution of her marriage solemnized with the respondent through the decree of divorce. The matrimonial relationship between the parties is not in dispute. The point for consideration in this petition is whether petition filed by the petitioner is barred by law. The respondent in his application under Order 7 Rule 11D of CPC claims that the issues involved in this petition has been directly and substantial adjudicated by the family court Gautam Buddh Nagar in the proceedings initiated by him in the petition number 318 of 2019. Since the petition filed by him in petition number 318 of 2019 has been adjudicated by the competent court having jurisdiction, the present petition filed by the petitioner for dissolution of marriage is hit by the principles
For
of res
example,
judicata.
if you file a petition seeking for restitution of conjugal rights,
yes,
that is allowed. That is allowed.
Yes, ma'am.
Then you will. Then the respondent will not join you.
The respondent does not join.
Then
me.
you will file a petition for divorce.
I don't file.
I'm just asking you a question. How do you answer it? Now, when a restitution is not honored and the wife has not joined the husband, husband will file a petition for divorce. According to you, that is barred by res judicata.
No, my lord. If the petitioner, if the party who has filed res judicata, who has filed a petition under section 9, subsequently the same party files under section 13, then principles of res judicata are not hit. That is the distinction that has been made, and I will submit the decisions to that effect, my lord. If and when the party who has filed res judicata and the other party does not appear in the proceedings or participates in the proceedings and subsequently files another petition here under section 13, then the principles of res judicata are applicable. That is the distinction that has been made, and I will show before this honorable court by way of the judgments. The respondent in his application, may I, my lord? Since the petition filed by him in the petition number 318 of 2019 has been adjudicated by the competent court having jurisdiction, the present petition filed by the petitioner for dissolution of marriage is hit by the principles of res judicata. Thereby, the respondent sought for rejection of the petition on the two grounds referred above. In the facts and circumstances of the case on hand, the point for consideration is firstly whether the petition filed by the petitioner is barred by law, and secondly whether the petition filed by the petitioner hit by the principle of res judicata. Even though the respondent has filed this application under Order 7 Rule 11D of CPC, he has not referred to the specific law or provision under which the petition filed by the petitioner is barred under law. The respondent claims that since there is a decree of restitution of conjugal rights passed by the family court Gautam Buddh Nagar on 21/2021 in petition number 318 of 2019, the petition filed by the petitioner is barred by law. Under Hindu Marriage Act, there is no bar for filing the petition under section 13(1)(1)(a) and 2(2) of the Hindu Marriage Act when there is a decree of restitution of conjugal rights. The issue adjudicated by the family court Gautam Buddh Nagar in petition number 318 of 2019 filed under section 9 of Hindu Marriage Act is completely different from the issues involved in the case on hand. Further, the petitioner admittedly remained ex parte in petition number 318 of 2019, filed under section 9 of the Hindu Marriage Act, and the decree of restitution of conjugal rights is admittedly ex parte decree. In other words, the petitioner did not participate in the proceedings held before the court under section 9 of the Hindu Marriage Act. The petitioner claims that the respondent filed the said petition referring to the address of her petitioner's house even after knowing that she is not residing in the said address. The petitioner claims that the respondent
was the legal version.
My lord?
We'll go to the legal version.
Yes, my lord. My lord, the first aspect is whether
Take the
issue of
give the judgment and then refer to
yes,
it.
I will definitely give the judgment as and when
judgment.
there are several judgments, my lord. As and when I start, I will give the judgments. My first judgment, my lord, is whether the idea of res judicata is applicable insofar as matrimonial laws arise. My lord, in 1981 to Supreme Court 646, that is Buddha Vijay Lakshmi case, it has been very clearly held, my lord, that insofar as the entire aspect of CPC is concerned is applicable for the matrimonial laws also. Yes.
That law need not
No,
be.
one of the reasons
Come
on
to
which.
No, I want you to straight away come on to that point, nothing else. All this is not required. It
Yes.
will apply. Why?
Yes, my lord. In which case I will start with another judgment. See Sarala.
What you can do is, you can pass on all the judgments and you can start relying on it instead of passing on one by one. Yes, 1991 Sarla, what is
Yes.
where is the
My lord,
relevant paragraph?
My lord, in this, the relevant paragraphs start with paragraph number 5. In this matter, my lord, what had happened is there were 3 petitions that were involved. One that was filed similar circumstances where there is res judicata and subsequently there is also another case for divorce, and subsequently there was also another aspect with respect to decision. My lord, I start with paragraph number 5. The essence of doctrine of res judicata is that the judgment of a court upon a point is conclusive between the same parties and is, as a plea, a bar, or as evidence conclusive in a subsequent proceeding. The rule of res judicata bars the trial of an issue which rose directly and substantially in a previous proceeding and has been adjudicated upon in such proceeding. The rule is founded by 2 principles. Firstly, a litigant should not be vexed twice for the same cause, and secondly, public policy requires that all litigations must end at the same point of time. Although the doctrine of res judicata finds legislative expression under section 11 of the Code of Civil Procedure, the section is not exhaustive of all the circumstances in which an issue may be res judicata. The doctrine exists from the limited compass of section 11 of the Civil Procedure Code. The doctrine has been applied to cases to which section 11 does not strictly apply. It has been applied to execution proceedings, to a subsequent stage of the same proceeding, to special acts like debt relief acts and consolidation of holding acts, displaced to orders of remand, and to awards under the Arbitration Act. It has been stated that the doctrine of res judicata applies to cases under various special acts. In our opinion, it should be applied
What is res judicata according to you?
My lord?
Res judicata means what?
My lord, res judicata is when you cannot, when there is already an issue that has been decided substantially.
What is the issue in a restitution petition? What is the issue in a divorce petition?
My lord, insofar as the reliefs of the 2 aspects are different, however, the issue that are related are substantially, and
I want a direct judgment on that, nothing else.
My lord, this honorable court may kindly look at the next paragraphs.
I've seen the entire judgment.
My lord, it may be looked into the fact that when there is one order of the court that has been passed, which has been reduced to a decree, which has been reduced to a paper decree, only for the fact that they have decided that they are not going to, that they will not appear. Neither have they sought for either, review of the order or recalling of the order, or nor have they challenged it. Absolutely nothing has been done. An issue with respect to res judicata, my lord, if the other party has options or opportunity to provide the same aspect as defense there, then it is considered that it is directly and substantially an issue. This, my lord may kindly look into this judgment.
Yes, repeat.
It has been stated, the OP HMA 49 of 1975 by the husband for the decree of restitution of conjugal rights, and OS number 60 of 1970 by wife was for maintenance. In both proceedings, wife raised one defense. The husband bet her, treated her with cruelty, and compelled her to leave the matrimonial home. The husband and wife led evidence on this question and invited the finding from the court. The finding was necessary because because if it went in favor of the wife, she was justified in living away from the husband, disentitling the husband to a decree for restitution of conjugal rights and entitling the wife to maintenance. For this reason, the finding on this matter was directly and substantially in issue in the previous proceedings. In the present OP 49 of 1981, the husband once again urges that the wife deserted him on 29/8/1974. In the previous proceedings too, he had pleaded desertion with reference to the same date. The defense of the wife is that she was driven out after cruel treatment. The essence of desertion is that wife had animus desidendi. It has been found in the 2 earlier earlier proceedings that the wife did not leave the house voluntarily but was beaten and driven out. There is therefore a conclusive finding in two previous proceedings between the same parties that the wife did not intend to leave the husband or the matrimonial home. This finding was delivered on a matter which directly and on a matter which was directly and substantially in issue. Therefore, husband is precluded from raising the question of desertion by the wife in OP number so and so. The reason is that the two previous proceedings, there is a conclusive finding that the wife's act of living and the husband lacked the essential element of desertion, animus desidendi. I stop here for a while, my lord. In this case, the aspect of previous husband, there has been an issue with respect to section 9 has been filed. Subsequently, it has gone against. Subsequently, the husband goes ahead and files again. Only on the basis of the remarks that have been held there, the subsequent proceeding has been considered to be hit by res judicata. Therefore, my lord, if where an aspect has been, if the party had an opportunity to take the same pleadings as defense in the previous petition, then the issue is substantially, and the issue has been held substantially and to be decided substantially in the matter. My lord, with respect to my lord, in this case, by the High Court of Judicature at Allahabad, paragraph number 6 refers to the facts. Paragraph number 11 to 15 are relevant. Paragraph number 11, my lord. The principle of res judicata, may I, my lord?
Yes.
The principle of res judicata has been codified under section 11 of the Civil Procedure Code, which reads as follows. I would not read that. Paragraph 12. The principle enunciated in section 11 of the Code of Civil Procedure would be on the term issue used under section 13 of the Hindu Marriage Act 1955. Section 13 of the Hindu Marriage Act 1955 provides for grant of divorce in certain cases. It enacts that any marriage solemnized whether before or after the commencement of the act may be dissolved on a petition presented either by the husband or by the wife on any ground specified therein. Clause 1A of the subsection 1 of 13 of section 13 of Hindu Marriage Act declares that a decree of divorce may be passed by a court on the ground that after the solemnization of the marriage, the opposite party has treated the petitioner with cruelty. From bare reading of the above provision, it appears that the principles of res judicata under section 11 of the Code of Civil Procedure is based on the rule of law that a ground shall not be fixed for one and the same cause. The only thing that the court has to see is that whether the new suit is in fact founded upon a cause of action distinct from the foundation of the former suit. I stop here for a while, Manor. The cause of action that has been sought for by the petitioner wife is in fact the same aspect. It has been claimed. If this honorable court may kindly look into the petition.
Please complete it. Please complete this and then.
Very well, very well. In this case, even if the second suit under consideration would have been filed on some other ground, which was not a ground in the earlier suit for dissolution of marriage, yet by virtue of application, so and so, case of it's referred to in the case in the state of Maharashtra and another versus National Construction Company, Bombay, and another reported in AR 1996. Paragraph 9 of the judgment reads as follows: both the principle of res judicata and rule 2 of order 2 are based on the rule of law that a man shall not be twice vexed for one and the same cause. In the case of Muhammad Khalil Khan and Mehboob Ali Khan, AR 1949 PC at page 86, the Privy Council laid down the tests for determining whether Order 2, Rule 2 of the Code would apply in a particular situation. The first of these is whether the claim in the new suit is in fact founded upon the cause of action distinct from that which was the foundation of the former suit. If the answer is in the affirmative, the rule will not apply. The decision has been subsequently affirmed by two decisions of this court in Cable Singh versus Lajwanti and in Aikesho Martin's case. In the present case, apparently, the first matrimonial case for dissolution of marriage filed by the appellant under Section 13 of the Hindu Marriage Act was filed on grounds of cruelty and desertion. In para number 11 of the first matrimonial suit, the appellant had stated that the cause of action in filing the first matrimonial suit accrued on 25/4/25 when the respondent refused to perform her marital obligation and refused to go for a settlement. Whereas the second matrimonial suit, that is suit number so and so, in paragraph number 21, the appellant has the appellant has filed the matrimonial suit based on subsequent and fresh cause of action relating to the infliction of cruelty and desertion on a subsequent date. And as such, the second divorce petition is very much maintainable and the principle of res judicata does not apply. My lord, I will stop here. It has to be reminded that the cause of action means bundle of facts constituting the right of a party which he or she has to establish, and in order to obtain a relief from the court, and the same has to be tested in the anvil of evidence led by the parties. In the present case, there is no adjudication on the fresh or subsequent cause of action which has been raised by the appellant in the second matrimonial case. No doubt the appellant raised the ground of cruelty and desertion and filed the present second case for dissolution of marriage. However, it is apparent from the plain reading of the second matrimonial case for divorce that the cause of action pleaded was different in the earlier suit, and as such, this court does not find any legal impediment in maintainability. My lord, this case, though it has been held against me insofar as the facts are concerned, the rule of law that has been established here is that the facts that are founding the cause of action must be different. If this honorable court may kindly look into what has been pleaded in the petition and
For a
whether
decree of
these
restitution or for a decree of divorce, always cause of action will be the same the day you got married. How can you compare that with this?
My lord, the question is whether these aspects could have been taken as defense in petition number 318. If they could have been taken as defense in petition number 318, yes, then it is a bounden duty upon the respondent wife to be there.
It's an ex parte
decree. It's an ex parte decree.
Immediately
My lord, subsequently, my lord, I would want to bring before this honorable court the small conduct of the wife. There was another GNWC petition that was filed before the Gautam
family court decide.
My lord,
I'm not,
my lord, in that case, the same petitioner wife went ahead and has appeared. In this matter, she chooses not to appear.
All those things we can't consider in an order 7 to
this
11.
Literally sanctions the fact of reducing that to a paper decree by implied disobedience.
Any other judgment? Give that judgment also. This judgment. Give any other judgment.
My lord, the matters are substantially, the matter has been wherever there is a defense that has been taken.
I'm not convinced on that.
My lord, in this,
may I
if the cause
assist the
of
court
action
with
is
a
different, my
judgment
lord.
that is on point this
Yes.
only one judgment, my lord. Also for the benefit of the court, kindly see the page number 24, annexure 4, my lord. The Uttarakhand High Court, seeing a similar matter in Balveer Singh versus Ajit Kaur, has said that res judicata does not apply.
Where is that?
Kindly see, my lord, the paragraph numbers will be para number 9, my lord, on page 26.
Let's see from para 4 so that it will.
Certainly, my lord. So the principles of res judicata enunciated in section 11, that is not in dispute.
Yes.
Restitution of conjugal rights, the definition of it is not in dispute. And section 9, para 5, my lord, on a simpliciter reading of section 9 of the Hindu Marriage Act, it has altogether a different purpose. The purpose of section 9 of Hindu Marriage Act is to meet a contingency. It deals with a situation where a married couple for no justifiable reason is withdrawing himself from discharging the obligations attached to the institution of marriage, which at the hand of one of them is attempted to be settled together. The grant of relief of the restitution is subject to the satisfaction being established of non-meeting of the matrimonial obligations. To elucidate it further, the conjoint consideration of section 9 read with section 13A is relevant. Whereas section 13A of Hindu Marriage Act deals with the alternate relief in divorce proceedings, where the court in the principal proceedings under section 13(1) and its subclauses alternatively feels that instead of dissolving the marriage, to grant a decree of judicial separation, and yet again is only an enabling provision to the court to have an alternate recourse of judicial separation instead of dissolving the marriage under section 13 for raising institution of marriage. It would be reasonable to infer that the invocation of section 13A is enabling the court to have situation to meet and grant an alternate decree of judicial separation instead of dissolution of marriage. Relevant paras are now, my lord. If both the provisions, if are scrutinized harmoniously, the legislature in all its wisdom had provided that the two sections, section 9 and section 13A of Hindu Marriage Act, provided to meet a separate set of contingencies while maintaining a matrimonial relationship and its continuance. Under no set of circumstances or reasonableness, section 9 deals or touches the issue which is either covered by section 13 or by section 13A of the Hindu Marriage Act 1950. Thus, both the provisions are divergent to one another. One aims to bring the family together, and the other is a judicial process to separate the family for the grounds provided under section 13 of Hindu Marriage Act and to meet a different purpose. Hence, adjudication made by the court under any of the aforesaid provisions, this court feels would not attract section 11 of this Code of Civil Procedure to create a bar in filing a subsequent suit under either of the provisions under section 9 or 13A of Hindu Marriage Act. Even otherwise so, if a proceeding under section 9 is initiated by any other party to the family disputes, its allowing would be ending up of the controversy between the parties or will aggravate the dispute between them. Allowing or rejection of section 9 will not create any impediment for section 13 and section 13A as they are independent to section 9. Thus, section 9 will not eclipse the statutory effects of section 13A. Thus, the bar of section 11 of CPC will not come into play. Not coming to para 11, the contention of the appellant in the case at hand to the effect that suit number so and so preferred under section 9 since has been decreed, hence proceedings under section 13A would not be maintainable is a misconception. In the present case, the appellant's stand is since section 9 has been decreed, hence section 13 would be barred by section 11 of the code CPC. This analogy is not accepted for the rationale that in the case at hand, section 9 was decreed prior to the filing of section 13A. It will not have any effect on section 13A for the simple reason because if section 9 is either decreed or dismissed, it will not take away the right of a party to file section 13 for dissolution of marriage at any subsequent stage. Hence, also from this viewpoint, section 11 will not be attracted and both the proceedings either under section 9 or 13 and 13A is to be decided independently. Well, the objection of the government of the petitioner here, I mean the husband here, says that because he obtained an ex parte decree in RCR, wife cannot file something in the divorce petition in Bangalore under different grounds. She has filed it under cruelty. That is permissible. There is no specific bar. My lord, the husband here, my lord, has not disclosed that similar writ petition was filed earlier. That order has not been made a part of it. I have included that order, my lord, in page number 11 of this honorable court. Coordinate bench has already dismissed a similar petition filed exactly with the similar wordings in the petition, saying that at that time, my lord, there was an issue. The order of the learned trial court went missing. Because of that, this honorable court told res judicata won't be applicable, but because
Petitioner husband files an application in I number 7. On the soul, it was barred by law. The wife files her objection. Same impugnment, same order.
Same thing, my lord.
Then how can they file the second writ petition?
My lord,
How can they file the second writ petition?
the second they have filed the second petition.
May
Basically,
I
the
produce
first
that
one,
order? I will
the
produce
first
that
one
order
was,
before.
my lord, because they sought res judicata, not allowed, but because the order was missing, certified copy was not made available in the trial court.
It is
This
allowed in
honorable
part
court
of the
took upon it himself.
Bangalore so and so filed with the petitioner stands quashed. The consent court is directed to restore I number 8 filed with the petitioner 7 afresh. After this is passed.
Correct, my lord.
Yes, please come.
Also, my lord, the page number 20 and 22, they have not informed this honorable court that the transfer petition filed, their contention, my lord, is that the RCR petition filed in Gautam Budh Nagar, Noida, we have to go there and challenge it. Already, my lord, honorable Supreme Court has transferred the guardians and wards petition that they filed there to Bangalore. Kindly see page number 20.
No, that is not relevant.
That is only to show the conduct, my lord. That
Conduct nothing.
both they filed one.
My lord, my humble submissions.
Yes.
With respect to two aspects, one with respect to writ petition 25522, my lord,
The
it's not.
aspect I'm not at all going into.
Yes, my lord, it's not the transfer part of it.
I am not at all going.
The
Why you are
previous
concerned
writ
with
petition, the
GNWC
previous
and
writ
all?
petition does not bar me from filing this writ petition. Yes.
I'm not
In so
going
far
with
as the second aspect, my lord, the submission that has been made with respect to Balbir Singh's case, my lord, what in this is not applicable because in this case the same party files section 9 and section 13. My lord, wherever a same party has filed section 9 and subsequently section 13, under those cases, res judicata, my humble submission, my res judicata is not applicable, my lord.
I'm not convinced. I'll record your reasons for that, your arguments. The present writ petition is filed, agreed with the orders passed in order passed on an in I number 6 and 7, 6/7, dated 10/8/2022, where an application is filed under order 7 rule 11D to reject the plaint as the same is barred by the judicata. The application is filed with the respondent husband, stating that already the husband had filed an MC, that is MC number 318 of 2019, before the Additional Principal Judge Family Court, Gautam Budh Nagar, and the wife remained ex parte, and an ex parte judgment and decree was passed on 21/2021. Thereafter, on 8/9/2021, the wife had filed the MC seeking divorce on the ground of cruelty,
And sodomy.
And
under 13(2)(2), my lord.
What is that?
Rape, sodomy, and bestiality.
They filed the divorce on the ground of cruelty. The said application came to be rejected by order impio, and the court has observed that though the wife has filed this, though the husband has filed this application under order 7 rule D, he has not referred the specific law or provision under which the petition filed by the wife is barred under law. The court has also observed that the MC, the judgment that is passed is a ex parte order, and the wife has not participated in the said proceedings. And merely for the reason that the wife had not failed to prefer appeal against the decree of restitution of conjugal rights, or failed to file the petition for setting aside the ex parte decree, it cannot be concluded that the petition filed by the wife under section 13(1)(a) and 13 and 2 within brackets 2 of Hindu Marriage Act is not maintainable. And further, it is a settled position of law that the decree for restitution of conjugal rights cannot be enforced forcibly or under compulsion. And further, in the objections, it is stated that the wife is taking steps to challenge the ex parte decree passed in a restitution petition. The court had also observed that the relief that is sought in the restitution and the relief that is sought in the divorce proceedings are not one and the same. As such, the principles of res judicata will not apply in this case, as there are two different and distinct proceedings, and the petition that is filed by the wife is not barred under any law, and accordingly dismiss the petition. And counsel for the petitioner submits that when the husband has filed the MC seeking restitution of conjugal rights and when a decree is passed, the cause of action arose for the said suit on the day when the marriage has taken place and the day when the wife, without any reasonable cause, has left the matrimonial home. And even for the decree of divorce on the ground of cruelty, the cause of action is the same, that is the date of the marriage. It is submitted that the issue that is the issues between the parties are already are decided by the court, and as the wife has not participated, as it's an ex parte order, it's for the wife to contest the said. It's for the wife to take steps to question the said order, which the wife has not chosen to do. All the findings, the court has decided with regard to the matrimonial life of the parties. In the give that also matrimonial life of the parties. In that case, when the issues were directly what the when on a, the and the same issues cannot be decided by the court, and the same is barred by res judicata. She has relied on the judgment of the High Court of Judicature at Allahabad, Lucknow, in the case of in first appeal number 122 of 2023. She has relied on paragraph number 11 to 50 extract. She had relied on 1981 two Supreme Court cases 646 in case of Guda Vijayalakshmi versus Guda Ramachandra Shekhar Shastri to submit that the principle of res judicata is also applicable as well as the family courts are concerned. She relies on the judgment of the apex court in C. Sarla versus K. Nalinakshan, reported in 1991, AR 1991 Kerala 362, the judgment of the Kerala High Court. She relied on paragraph number 8, 9, 10, 11, 12, and 13. Relying on these judgments, Land Council submits that the present suit is hit by res judicata, and the court ought to have allowed the application that's filed by the husband under Order 7, Rule 11D. Land Council appearing for the respondent submits that. Respondent wife submits that. The dismissal of the earlier the ex parte judgment and decree that's passed in a restitution of conjugal rights case will not preclude the wife from filing MC seeking divorce on the ground of cruelty. He had drawn the attention of this court to the judgment of the Uttarakhand High Court in case of Balbir Singh versus Harshit Kumar, reported in AR 2007, 17, Uttarakhand 175. And we have relied on paragraphs 4, 5, 6, 7, 8 till the end. Relying on this judgment, Land Council submits that court had categorically considered all the issues that arise. It is submitted that the facts and circumstances of this case and the other case and in Balbir Singh's case are similar, and the court had considered whether any order that is passed under in a restitution of conjugal case will operate as a res judicata to initiate the proceedings. He submits that the court has decided whether it is allowed or dismissed. So in that case, there cannot be any distinction that if a person who files a restitution case can file a MC and a party who is a respondent in a restitution cannot file an MC, and there is no MC for divorce, and there is no such distinction drawn. And relying on this judgment, it is submitted that the court has passed a reasoned order. Both the counsels have argued on the JNWC case and the conduct of the parties, and both the advocates have advanced the arguments. This court is not inclined either to record the submissions in that regard or to go into the said aspect, because the issue that is before this court is whether the order that is passed by the court in an application filed by the application filed by the husband is justified or not. Next, having heard the counsels on either side, there is a material on record. In this case, the husband has filed a restitution case, he has filed a case seeking restitution of conjugal rights at Noida, and an ex parte judgment and decree was passed on 21/20/21. Thereafter, on 8/9/2021, the wife had filed this MC seeking divorce. The contention of the counsel for the petitioner that the issue in section, that is decided by the court and the judgment that is passed in a restitution of conjugal rights case operates as a res judicata for initiating the proceedings for MC. This court is not able to appreciate the said contention, and the submission that the cause of action for the same would, for both the cases, would be the same. Also as no, even that submission has no legs to stand. When it comes to the restitution, the party would be mentioning about the date of marriage and the day when the wife is left. When it comes to the MC seeking divorce on the ground of cruelty, there are several instances or cause of action for the wife seeking such relief. At any stretch of imagination, both the cases, it cannot be held that they are barred by res judicata. In Balbir Singh's case, the court has dealt with the issue in detail, wherein it has discussed about section 911 of the Code of Civil Procedure, which provides that no court should try any suit or issue in which the matter directly and substantially in issue has been directly and substantially decided in a formal suit. Whereas the reliefs that are sought and the issues that would be framed and the issues that would be decided in a case for restitution and in a case for divorce can never be directly and they have no nexus, and the court has to, the issues in both the cases are different. And hence, in the considered opinion of the court had rightly come to the conclusion and rightly dismissed the application. No grounds to interfere. Dismissed.
Is this court to have this matter concluded in about 6 months, my lord? Direction maybe.
Here.
21 matter, my lord.
21, which court?
No, this particular,
Which court it is pending?
the third additional court.
Family
Court.
Yes.
Obliged.
Cell number 37. Venkatesh R. Bhagat.
Yes. What do you say?
Yes, regarding that, my lord, the principle laid down in that case is not. In this case, my lord, section 125 gives rise to two situations. One, as a wife, during the subsistence of the marriage, she can file a petition. By virtue of explanation, a divorced wife also can maintain a petition under section 125. Now, in this case, my lord, I have obtained the section 9 order for RCR.
No, that's what it is.
Yes,
What the court, that's a distinction drawn.
Yes, ma'am.
Now, there are two eventualities. One is you are entitled for maintenance as a wife.
Yes.
And as a divorced wife.
Yes.
So what did the Supreme Court say?
Yes.
When you wanted the maintenance as a wife and when there is desertion and that 125(4) will come into play when you are a wife and a status of a wife.
Yes.
When you are a divorced wife, that to that 125(4) has no application.
No,
is what they said.
come to both, my lord. Wife,
that's no, but that's why we'll read that particular paragraph. That's what
Yes.
I read it.
Yes. I will
Please come to that.
First, in the wife used in 125(4) may be kindly seen, my lord.
No. Let's see the judgment.
Yes.
That is very clear.
Yes.
Please come to this Rohtash 2003 Supreme Court cases.
Yes.
You please read paragraph number 10. Let's read paragraph number 10.
Yes. The claim of the maintenance under the first part of section 125 is based on the subsistence of the marriage, while claim for the maintenance of the divorced wife is based on the foundation provided by explanation B subsection 1 of section 125(7). If a divorced wife is unable to maintain herself and if she has not remarried, she will be entitled to maintenance allowance. The Calcutta High Court had an occasion to consider an identical situation where the husband had obtained the divorce on the ground of desertion by the wife, but she was held entitled to maintenance allowance as a divorced wife under section 120 of the CRPC. And the fact that she had deserted her husband and on that basis a decree of divorce was passed against her was not treated as a bar to her to claim the maintenance as divorced wife. Yes, well, we approve these decisions as they represent the correct legal position of law.
Further.
Para 11. Learned counsel of the petitioner then submitted that once a decree of divorce was passed against a respondent and marital relations between the petitioner and the respondent came to an end, the mutual rights, duties, and obligations should also come to an end. He pleaded that in this situation, obligation on the petitioner to maintain the woman with whom all relations came to an end should also be treated have come to an end. This plea, as we have already indicated above, cannot be accepted as a woman who has two distinct rights for maintenance. As a wife, she is entitled to maintenance unless she suffers from any of the disabilities indicated in section 125(4). In other capacity, namely as a divorced woman, she is again entitled to claim maintenance from the person of whom she has once a wife. Women after divorce become destitute. If she cannot maintain herself or remains unmarried, the man who has once her husband continues to be under statutory duty and obligation to provide maintenance. Yes, sir, I am not disputing this aspect. Yes, sir. The learned counsel for the petitioner then contended that maintenance has been allowed to the respondent from the date of the application. The application
That is not relevant.
Yes, this is not concerned. Regarding the date of application, they have approved this.
Then.
Yes, sir. Now, what I am telling, I am not disputing that both wife and the destitute wife is having a right to maintenance. Now, what I am telling, my lord, 125(4) is applicable to wife. There is no distinction as to the only.
No. That is there. That is there. That is what is made at paragraph above paragraph 11.
Yes, ma'am.
It is made.
Yes. As a wife, she is entitled to maintenance.
Calcutta High Court judgment, where they said that, look at it, if the divorced wife is unable to maintain herself and she has not remarried, she will be entitled to maintenance.
Yes.
The Calcutta High Court had an occasion to consider an identical situation where the husband had obtained a decree on the ground of desertion. Same like in your case.
Yes. But my lord, what I am telling here, I have obtained here section 9 is discussed. What I am telling. On the ground of
Section
desertion.
9, no. More than section 9.
Yes.
The divorce on the ground of desertion is all the more a ground for
Yes,
you.
well, what here two space will come.
No, this order has no. You have to look at the desertion order.
Yes, well.
So please read it.
Yes.
Where the Calcutta High Court had an occasion to consider an identical situation where the husband had obtained divorce on the ground of desertion by the wife. So already she is a divorced wife in Calcutta High Court judgment.
Yes, well.
But she was held entitled to maintenance allowance as a divorced wife under section 125 CRPC, and the fact that she had deserted her husband and on that basis a decree of divorce was passed against her was not treated as a bar to her claim for maintenance.
Yes, madam. I'm with that one. I'm not.
If you don't have claim, then she's entitled.
No, my lord. Then I will tell you, my lord. Here it has been stated in subsequent judgments, the Supreme Court stated that even though a decree has been obtained for desertion, she has to come and plead before the 125 court that she was willing, circumstances under which she cannot go and join. She has to explain.
No, as far as this judgment is concerned,
This has been reasserted. Then,
precisely on the point,
Yes,
the court has dealt with it.
yes, ma'am.
So why should we not consider a judgment of judgment in this case? 2003 SCC.
Yes, 25.
No,
it has
no, in
been-
the other case, when he
Yes.
has already followed the same judgment.
But it has stated that when this such kind of situation.
Please come to that
Yes,
paragraph.
yes, ma'am. Yes. Para 18 may be seen, para 21.
Yes.
In Babita versus Munnala, the Delhi High Court opined that an ex parte decree of restriction of conjugal rights would not automatically put any end to the wife's right to maintenance under Section 125 of the CRPC. It was held that even if such case is contested by the wife is decided in the husband's favor, non-compliance thereof could be taken to be ground to deny maintenance, provided that court is satisfied on the strength.
Babita versus Munnalal, it's a Delhi High Court judgment.
Yes,
it is a discussion part of the judgment.
Yes, well,
There is
then
no
what
law
is
laid down.
stated there, my lord?
No,
That's
no.
what I'm telling. Say, my lord, provided satisfied on the strength of the evidence
That
that
is a
wife
law
had.
laid down, Mr. Counsel, that's a law laid down in Delhi High Court judgment. There is no consideration by the court. Court is only discussing.
No, wife has to. It's just,
So that
wife,
I understand.
how on the 125.4, how it can be
It's a Delhi High Court
diluted.
judgment, Delhi High Court
Then-
judgment.
yes,
Delhi
my
High
lord.
Court has
Then
considered.
it has, then my lord,
This is all extraction, all
yes,
of
ma'am.
these
Yes,
extractions.
ma'am.
You
Now-
have to come to the ratio.
yes, my lord.
Where is the
is-
ratio?
Yes, my lord. She has to state that.
That is the Delhi High Court judgment. We will not, whatever is extracted, we will not go.
Yes, madam.
In this particular judgment, what is the ratio laid down?
Laid down is, I will take a lordship.
So please come to that.
Yes, ma'am. Para 36.
Yes.
Pertinently, in Praveen Mehta versus Indrajit Mehta, this court held that mental cruelty is a state of mind and feeling of one of the spouses due to the behavioral pattern by the other. And unlikely physical cruelty, mental cruelty is difficult to establish by direct evidence. It was observed that a feeling of anguish, disappointment, and frustration in one spouse caused by the conduct of the other can only be appreciated on the cumulatively assessing the attending acts of facts and circumstances in which the two spouses have been living. In the case of mental cruelty, per this court, it would be not be correct approach to take any instance of behavior in isolation and pose question whether such behavior is sufficient by itself to cause mental cruelty. The approach should be to take the cumulative effect of the facts and circumstances emerging from the evidence on the record and they draw a fair reference whether the spouse has been subjected to mental cruelty due to the conduct of other. Applying this standard, Dinesh's conduct is completely ignoring his wife. Reena, after she suffered the miscarriage of their would have been proverbial last straw added to her suffering due to the ill treatment in the matrimonial home. She therefore had just cause not to return to her matrimonial home.
Those are all the facts of the case.
Yes, sir. In this background, in this factual background, there it was held that a wife.
Ultimately, they have said the
Yes,
husband
madam.
has disowned
But
his
there it is
responsibility.
proved. But I will take a lordship to the facts and evidence in this case. Yes, I am telling you, law is. I am not disputing the law.
We are on law. We are on law.
Yes, madam. Whether that fact is applicable, the facts are supported.
No.
I will take a lordship.
Please understand, as per the judgment in that 1990
Yeah, the
Supreme Court
2003,
case,
2003.
it is very clear
Yes,
that
madam.
that 125(4)
Yes.
is applicable to a wife, but
Yes.
not to a divorced wife.
Yes.
So what are all the facts and what are all the merits you have with regard to desertion,
No,
with
but
regard to
here
restitution, will not apply.
No, but two facts are there. Petition was filed during the subsistence of the marriage. These dates are very important, madam. Restitution was happened during the subsistence of that petition. Divorce was also during the subsistence of the petition.
Correct.
Yes,
But
ma'am.
ultimately,
So
when the
date is
order
very
is
important,
passed,
my lord.
when the order is passed, when is the order passed?
Yes, order passed in 2024, my lord.
2024.
Yes, ma'am.
So when was the divorce?
2000, yes, ma'am. I'll just give the dates, ma'am.
As on the day, as and under the and the status of a divorced wife, the order is passed.
Yes, ma'am. But what I'm telling, my lord, the reasons for her mental cruelty or otherwise, no evidence at all before the trial court. Because now I come to section.
When you are asking for divorce,
No,
why would
no,
you do?
no, 125 I will come, my lord.
Only
This-
125 I have to.
125, beginning words of 125 may be kindly seen, my lord. That is not pleaded and proved. Just I will take your lord. This is her petition whether maintainable or not, one thing. Now I will come to 120 beginning one. 125 beginning words may be kindly seen. If any section 125, order for maintenance of wife, children and parents. If any person having sufficient means neglects or refuses to maintain it, that is not there. That is not pleaded proved. I have not neglected or refused. I have called her to come and join me, file the RCR, issued a notice, come and join me. Then she files a criminal case. Then she files this 125 petition. That's what I'm telling, my lord.
You're trying to submit your arguments in a different manner.
Yes, ma'am.
Which will be again contrary to that order.
No. What I'm telling, my lord, I'm not telling a.
If the wife deserts you, if the wife deserts, that means it is not you who has neglected her. Even in a desertion case also,
yes,
that means you are ready to take care.
Yes,
she didn't join.
Yes.
So a decree of divorce on desertion
Yes.
is passed.
Yes.
So these two sentences which you have just now read have to be read in the context of the judgment.
Yeah, her evidence will be one paragraph evidence, madam. Just their evidence will be seen, madam. But some evidence is required, madam, regarding my neglect.
So here, what it comes, a wife who is not in a position to maintain herself.
Madam,
she's a divorced wife. Why will she come to you now?
Yes, madam. What I will tell, madam. I had
divorced wife. Why
Yes.
will she come to you?
No, not it. First I sought, madam. Then I.
That's over. By
Yes.
the time the order is passed,
Yes.
she's a status of a
For
divorced wife.
a wrongdoer is defaulter shall be benefited or not. This I will leave it to your lordship.
When was the divorce granted?
Yes.
What is the date of divorce?
Yes. That, my lords, I just these on 7 dates I will give your lordship. Take that, madam.
Yes.
I have issued the legal notice for RCR on 8/5/2018.
Those are not necessary. I want the dates.
Yes,
when
madam.
when this criminal misdemeanor
25/10/2000, 6/7/2022.
is a criminal miscellaneous.
Divorce was ordered, madam.
Divorce. Yes.
6/7.
Uh,
On 25/10/2018, RCR was allowed, madam.
on 25
10/2018.
10/2018.
18.
RCR.
6/7/2012, decree for divorce.
6/7.
2022.
Already you said so.
Yes, madam.
Uh,
My lords, now
when is the criminal miscellaneous filed?
criminal miscellaneous filed on 28/6/2018.
28/6.
8/6/2018.
8/6 to. Huh?
But it is filed on 8/6/2018. That is, date is there, but they are filed on 8/6/2018.
8/6/2000 criminal
18.
miscellaneous.
Yes, ma'am.
When is the order passed?
Order passed on 3rd September 2024.
3rd September
2024.
2024.
Yes.
So, what we'll say is, she is entitled for maintenance, whatever amount that is granted from after 6/7/2022.
No, madam. No, it's a given on the date of order only. It is given date of order only.
only.
Yes, madam. That is I'm not telling you.
Then no, nothing.
This is one thing, madam. Then, my lord, second aspect, I specifically pleaded and proved she is gainfully employed. That is not considered at all. I filed my affidavit of assets and liabilities. I specifically stated.
What is supported by what evidence?
Yes, madam. I have taken notice to very school where she is working. The address maybe.
Then what happened?
But that is not stated by her in assets and affidavit of assets and liability.
When you have taken notice, they have come to the court? Have they given any evidence?
She only not given any evidence, my lord. One paragraph that may be cited. I will read out, my lord. Her evidence may be kindly seen, my lord. Nothing. Just I will take your lordship to that evidence, my lord. Otherwise, I would not have been argued this much, my lord. Her evidence may be kindly seen, my lord. With this evidence, if this maintenance is granted,
What is this, which case number? This 7.
sorry, just I flagged it and kept.
In the meantime,
Yes, yes, my lord. I am having here.
I will take the other case, please.
Yes, my lord. It's there, my lord.
Yes,
That LCR has been called, my lord.
but that's in Kannada.
Yes, I just have read.
You can read.
Just see, my lord. That page may be seen, my lord. What is her evidence? That page may be kindly seen. 10 lines. That's all evidence. PW1. LCR ನಲ್ಲಿ page 8 ಅಂತ ಇದೆ ನೋಡಿ. ಹೌದು. 18/1/2019 chief. ಸವಿತಾ ಸಂತೋಷ್ ಅಂತ ಇದೆ PW1. ವರದಕ್ಷಿಣೆ ತೆಗೆದುಕೊಂಡ ಅದೇ ಒಂದು ಪೇಜ್, ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಲ್ಲಿ 3 ಲೈನ್. ಎಸ್, ಇದು ನೋಡಿ ಸ್ವಲ್ಪ ತೋರಿಸಿ. 9 lines evidence.
Yes.
That what he stated, I will let it. Just I will read out, my lord. Your lordship will understand that. And other ನನ್ನ ಮತ್ತು ಎದುರಾರ ಮದುವೆ ಜೂನ್ 2014 ಆಗಿದ್ದು ನಮ್ಮ ವೈವಾಹಿಕ ಜೀವನದಲ್ಲಿ ಎರಡನೇ ಅರ್ಜಿದಾರ ಹುಟ್ಟಿದ್ದಾನೆ. ಆಮೇಲೆ she says our marriage is solemnized, second petitioner is born. ಎದುರುದಾರರು ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ ತೆಗೆದುಕೊಂಡು ಭಾಗ ಹೇಳಿ ನನಗೆ ಆಗಾಗ ಕಿರುಕುಳ ಕೊಟ್ಟಿದ್ದೇನೆ. he was troubling me for dowry. ಎದುರಾರು ನನ್ನ ಕಿರುಕುಳ ನೀಡದೆ ಮನೆಯಿಂದ ಹೊರ ಹಾಕಿದ್ದು ನಾನು ನನ್ನ ಅಕ್ಕನ ಮನೆಯಲ್ಲಿದ್ದೇನೆ. because of that cruelty I was staying in my sister's house.
Yes.
ನನಗೆ ಯಾವುದೇ ಉದ್ಯೋಗ, I am not having any employment. ಎದುರುದಾರರು ಮತ್ತು ನನ್ನ ಜೀವನಕ್ಕೆ ಯಾವುದೇ ವ್ಯವಸ್ಥೆ ಮಾಡಲಿಲ್ಲ. the defendant is not made any arrangement for the maintenance. ಎದುರುದಾರರು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಸೇಲ್ಸ್ ಇಂಜಿನಿಯರ್ ಆಗಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದು ತಿಂಗಳಿಗೆ 50,000 ರೂಪಾಯಿ ಪಡೆಯುತ್ತದೆ. he is working as a sales engineer earning 50,000 salary, and he is having land in Hunsur, and he started a new tech company, and he is having income from that also, but he is not taking care of myself. I am not having any income, so I filed this application. That's all.
What else you will say?
Well, regarding why she has not gone despite the destitution, I have filed a detailed objection and cross-examined her.
When is the chief examination date?
18/1/2019. Thereafter, I filed an objection and detailed cross-examination has been done regarding all these RCR.
Again, you are going back to the very same submission about why she has deserted you.
No, what I am telling, my lord, I have willfully neglected. There is no evidence. This is one aspect. then my lord, my income is concerned.
That you
yes.
can submit.
Yes.
That you can submit.
Yes,
Let's not go to that aspect again.
Yes, ma'am.
We will please
Yes, ma'am.
argue on
Yes, ma'am.
what is the, what
She
is wrong
stated
with the
that
order.
in the I am having an income of 50,000. The trial judge says,
Please come to the order.
yes.
Yes. Come to the reasoning part.
Yes, madam. I will take your lordship to the page 16, internal page 16, ink page 31. Para 25 starts in the bottom of page 15, internal page 15, page 30. Even according to respondent, the petitioner is an unemployed and she has no any source of income. The respondent during the cross-examination of PWN has utterly failed to elicit fruitful information from the mouth of PWN that she is having sufficient source of income and she is earning, and even she is capable of maintaining herself among with her son. Even though the suggestion was made to PWN that respondent has already left the job at Rajiv Institute of Technology, Hassan, but however, she stated that respondent on his own reason left the said job. This is one part. I left the job and stated his own business and also establishes company in the name of Youth Tech, from which he is earning good source of income. Even though PW1 has not chosen to deny the suggestion that the land measuring 6 to 7 acres situated at Kamegowdanahalli is standing in the name of father of respondent Shivalingappa. However, PW1 says the lands are in the name of this respondent. Subsequently, it was transferred. However, she has no documents to prove that lands were transferred to the name of the father of the respondent. Even the PW1 has admitted that has not produced any documents to prove that this respondent is earning more than 5 to 6 lakhs per annum from agricultural lands. However, she admitted the photographs confronted to her that said photographs belong to the respondent and her children. Those photographs are marked as exhibit R6 and R7 subject to production of CD or negative. PW1 denied the suggestion that the respondent is not capable of paying maintenance to them, and even she is not entitled to maintenance for the hands of this respondent. The respondent, except taking contention that he is already left the job at Rajiv Institute of Technology, Hassan, where he was working as a lecturer, has not chosen to deny the fact that he has established his own company in the name of Youth Tech and he is running the business. The respondent is clearly and categorically admitted that he is BE MTech graduate and having good educational background, and he has worked as a lecturer at engineering college from he has earned good source of income. The respondent, in order to prove his defense, got examined himself at RW1.
You please place your bank details before the court. We will decide.
Yes, I will produce. I have filed the affidavit evidence, everything filed.
No, court says so at para 32.
Yes, madam. 128 may be kindly seen, madam.
No, I have read all those paragraphs.
Yes, madam. However, the respondent in his affidavit assets and liabilities disclosed that he is BE mechanic graduate. Even the respondent has disclosed that he is working as a freelancer and his monthly income is 15,000. However, in order to prove this fact, the respondent has not chosen to produce his bank details before this court. Even he has not produced his bank account extract. The respondent has not even chosen to produce his income tax return submitted before the income tax authority to substantiate his
You have
content.
not done it.
Yes, ma'am.
You have not done it. Without saying that, simply saying that my income is 15,000, how the court should believe.
15,000, madam.
That's what I'm saying.
Yes.
Without
I will
a
produce,
document.
Yes, I will produce.
Why you
madam.
did not produce
Yes,
before
ma'am.
the court as per the
Trial
statement?
court, I have not done this case. In
Not
trial court.
you in the sense is not you.
Yes, yes, ma'am.
It should have been produced.
Yes.
Nothing else. On that day, we will only look at your statement,
Yes,
no
ma'am.
other
Now,
arguments.
another one aspect, madam.
Yes.
After divorce, I am married. I am having a kid.
That we will consider.
Yes, this
Looking
is
at your
what
income,
I am
we will
telling, madam.
consider.
A
This court has
wrongdoer
heard
shall
the-
not be
this
benefited.
court
That's all my
has
contention, madam.
heard the counsels at length. The only aspect is what is the income of the husband. He has not, except stating that 15,000, he has not placed any document before the court. Hence, the court had considered as granted 10,000 per month to first petition and 5,000 per month to petitioner number 2. Is this matter?
My lord, one thing. Let her produce her bank statement because she is earning. Yes, ma'am. She is earning
This
employed.
is matter on 4th by that, this matter on, not 4th, this is matter on 7th by 4th. Both the parties shall place before this court the respective bank statements from
3 years, my lord. 3 years prior.
like when is the order passed?
Yes, my lord. From 21 onwards, my lord.
From 21 onwards,
Yes, ma'am.
both the parties shall place their bank statement before the court, and by 4th, they should file, and the same shall be served on the other side, and list is matter on 7th.
And another one thing, my lord, if she come before the court, my client is ready to settle by paying a permanent element. They are not coming.
No,
Once for all can
find out,
settle.
land counsel for the petition submits that he wants to settle the matter by paying a lump sum amount. Land counsel for the respondent shall get instructions in this regard.
And keep the parties present before the court, my lord. But never she is not coming anywhere.
Now, what has happened is,
No.
2018 you filed, but the divorce was granted on 6/7/2022.
22.
So
Yes.
before that, we are not concerned.
Yes.
So from 2021, we'll look.
Yes.
And let your client also be present on in the court on the day, August 8th.
Yes, ma'am. I will also keep my
Not August
complaint.
8th, August 7th.
Watch out.
Next.
39. 39. Do.
For the petitioner wife, my lord, we have filed the instant petition for enhancement of entry maintenance.
Where is her husband? Consider the petition is present, no representation for the respondent husband. This is the matter on 11th August.
My lord, one small submission, my lord. The trial court is, the proceedings before the trial court is kept suspended animation, my lord. The same may be vacated, my lord.
Is suspended. This is matter tomorrow for the, tomorrow. No, your case, you are the petitioner.
For 39, yes, my lord.
Sought for the, you sought for the
Yes, my lord.
stay.
Yes, my
Why
lord.
you
We
sought
didn't
for
sought for the stay, my lord. Stay was given by the honorable court.
Shall I vacate it?
Kindly, my lord. That's my submission.
How can there be a stay for enhancement?
Yes, my lord. That's why the proceedings have been delayed.
Give that. The wife had filed this writ petition seeking
Enhancement of.
seeking enhancement of the compensation. And on 7/6/2023, a coordinate bench of this court has suspended the order, has suspended the proceeding, has granted an order whereby the MC proceedings are stalled. Then comes the present petition is only seeking enhancement. For that, the proceedings before the trial court need not be stayed. Hence, the stay granted by the court dated so and so is vacated, and the trial court shall proceed with the matter. This matter on same date, 7th. Or what is the date given?
7.
Yes. Next 40.
Obliged, my lord.
7.
Next.
40.
My lord, in this matter, my lord, this matter is already settled, my lord. Hence, I am filing withdrawal application.
Take that. It is submitted that the parties have settled the disputes amicably. Hence, they want to withdraw the writ petition, and a memo is filed. Memo is taken on record. Dismissed as withdrawn. 41.
Serial number 41. 41 Jagdish KG. Dheeraj JK.
What proceedings you have filed criminal petition?
To vacate the maintenance.
No, which court has passed this?
Magistrate. I've filed the
Now, this writ petition to this court will arise only if it is filed with passed with the family court.
But that's a.
Where is the impugned order?
It's in page number 73, my lord.
Yes.
In the last page, in the.
I saw that. So how a writ petition is maintainable against this order?
My lord, in the similar matter, we have filed we have filed a MFA actually, not in this matter, I'm saying, in the similar matter, where the court has instructed us to file a WP, my lord. Hence,
You can't file a MFA, you can't file a writ petition.
but, okay, my lordship, I'll convert matter.
Convert what?
Convert this petition to criminal petition. Revision
Then it will
petition.
come to the criminal petition. No, there is another, in between there is hierarchy of court.
But even the, wait a minute, I'll seek an instruction.
First of all, I'll dismiss it, giving liberty to you. We'll give them liberty. Agreed by the orders passed by the judicial first class magistrate, whereby the maintenance is awarded at.
Yes, my lord, it's awarded.
Whereby the maintenance is awarded. You're seeking enhancement of
Enhancement of the maintenance, my lord.
whereby the maintenance is awarded. The wife is before this court seeking enhancement, and counsel appearing for the respondent submits that the writ petition is not maintainable as the order is passed by the magistrate. Against that, they approached the district court, and the same came to be dismissed. Against that, a criminal petition is filed, and the same is pending consideration. Considering the fact that this is filed by the judicial first class magistrate, a writ petition is not maintainable before this court, and the same is dismissed. Giving liberty to the petitioner to avail the appropriate remedy within a period of 1 week.
May be taken as withdrawn, my lord.
Dismissed as withdrawn. You don't want all remedy.
Okay, maybe liberty may be fixed.
If your liberty is not given, how can you file?
Yes.
The dismissed as withdrawn, giving liberty to file an appropriate petition within 10 days from the date of receipt of the copy of the order. Yes. Next.
42. Harish BS.
Petitioner in this matter, Lordship. It's in husband's appeal, Lordship. Husband's petition.
Already
Lordship.
respondent is served.
Yes, notice has been served upon the respondent, Lordship.
What is the impugned order?
Lordship, please come to Annexure A at ink page number 14, Lordship. And I bring you to the kind attention of this Honorable Court at ink page number 22, where it's an operative portion of the impugned order, Lordship. It starts from 21 of the.
Directed to pay interim maintenance of 13,000 per month. What is the interim or impugned order? I mean, the stay granted by this court.
No, Lordship, no stay has been granted by this Honorable Court. Instead of that, this Honorable Court was given a direction me to a deposit and litigation expenses of 20,000, Lordship, where I'm already completed the order of this Honorable Court, Lordship. And notice has been served upon the respondent to, Lordship, and they're not.
What happened to the court notice?
Now it's in the juncture of the petitioner evidence where the criminal petition.
What happened to the court's notice?
The court notice has been served.
Not served.
Lordship, by hand I taken the permission of the court to by hand summons, Lordship, where I am served upon the advocate on record and parties to, Lordship, where they are accepted.
They shall be
And
stay of
we
all further.
filed an acknowledgement before this Honorable Court on the 13th December 2024 itself.
This is served on the counsel appearing for the respondent. In spite of the same, hand summons are served. In spite of the same, there is no representation on behalf of the respondent. They shall be stay of all further proceedings pursuant to the order dated so and so.
Stay of proceedings, Lordship. They including the impugned order, Lordship.
That's what is granted.
Grateful, Lordship.
Yes, next.
Cell number 43 adjourned. 44. Syed Akbar Pasha.
No representation for dismissal on 18th of August.
Cell number 45 adjourned. 46. Chandan Sanjay Bhatt.
For dismissal on 19th August. No representation on behalf of either of the parties.
Cell number 47. Vijit.
This on 1st of September for dismissal. No representation on behalf of both the parties.
Cell number 48 at this court. 49. Venkataraji CM.
It is submitted, but the counsel for the respondent What is your name? So and so submits that. He has instructions to file. He has received the NOC Vakalat and he'll file the same. Lists the matter on 11th of August. Yes, 51.
Cell number 49, 40, 50, urgent, 51.
Yes.
My lords, for petitioner, my lords.
Where is the counsel?
My lords, I represent the petitioner, my lords.
It is served. Notice is served.
Yes, my lords, they had appeared, my lord. One Purnima had appeared, my lord.
Purnima is the respondent,
Yes, ma'am.
not the advocate.
It was posted
Purnima,
for
party's name is printed. Where is the interim order? The interim order dated 21/3/2025 is made absolute. This is matter after this matter for final hearing on 15th of September.
Grateful, my lords.
Though notice is heard on the respondents, no wakalat is filed.
Cell number 52.
For the petitioners in this case, my lords, for the enhancement of the maintenance, my lords. My lords.
In this also notice served. The seeking enhancement.
Yes, my lords.
Let's hear it.
Yes, my lords. My lords, I filed for a maintenance of 50,000 rupees, my lords. The court gave 25,000 rupees, my lords. My lords, my humble submission is, my lords, she's earning 74,000 rupees, my lords. The husband is earning 36 lakhs rupees per year, my lords. So it comes to 3 lakh rupees per month, my lords. In the trial court, it did not file a statement of that this assets and the liabilities. So an inference should be drawn in my favor, my lords. I'm furnishing a supporting judgment regarding this. When an husband chooses not to file assets and liabilities, an inference.
Basing on what you're saying that his income is 36 lakhs.
My lords, like I did not furnish any document to show the 36 lakhs, but I made an averment in my assets and liabilities.
Let's no, when you make a particular averment,
it is
the
my
party
duty
who
to
has
show.
to prove it.
But it the shift, I mean the onus will shift upon him.
Please come to the order. How the
Yes,
court has decided it.
My lords, para 11 will discuss this aspect, my lords.
Yes.
Of the impugn order.
Yes.
The petitioner has not filed affidavit in the respect of assets and liabilities. The respondent has filed affidavit in the respect of the assets and liabilities for non-agrarian the opponent. So, my lords, so I did not furnish any document to state that.
Children out of the wedlock?
Yes, my lords. They have 2 kids, my lords. 2 twins, my lords.
What is the age?
Presently they are 8 years, my lords. Now they are in the care and the thing of the other, my lords. So like I am taking care of the 2 kids, my lords. My lords, there is a huge income disparity, my lords. There is a 74,000 from the wife, but the husband.
Not in dispute that the parties herein are residing separately. Though the petitioner asserted that he is paying 30,000 per month towards the maintenance of petitioner and her children, excluding medical expenses, but to demonstrate the same, he has not produced a scrap of paper.
My lords, I am furnishing on the citation regarding this, my lords, like as
That's
to
not
that inference. My lords, my only submission is, my lords, there are 2 twins, my lords, but in this case,
what is the
they are not
notice?
a normal babies, my lords.
How it is served notice?
My lords, they are born within the 5 months of the pregnancy, my lords. So use medical expenses will be there, my lords. So I have furnished numerous documents, like before the trial courts. So stating my My lords, two child is recurring illness, my lords.
So what the court has observed that he's already paying 30,000.
Apart from this, they are telling.
So it's coming to 55,000.
But like he's not paying. Like, but they did not make any observation with respect to the 30,000. My lord, his application, it is only with respect to the children, my lord.
File agreed with the orders passed in I number 3 in MC number 54/24 dated 25th September 2024, whereby the court had granted maintenance of an amount of rupees 25,000 per month towards maintenance of twin daughters from the date of application, and also is directed to pay litigation expenses of rupees 30,000. The notice to respondent is served on it is served. That's what is that? How the notice is served?
Yes, my lord, it was served.
How it is served? I'm not able to see anything in that. What are there at? What is
Previous
office
day,
note?
I can see that.
This thing on what? Give that. I will pass orders tomorrow.
My lords, I do. Oblige. Yes, 50,000 rupees. I'm just seeking, my lords.
Council, as per the cost list, it shows that
Citation shall I furnish, my lords?
notice is served. Notice is served, but there is nothing has been placed on the record to show how the notice is served. Where is the postal shara? Nothing is been placed on record. Registry is directed to place the same. List the matter tomorrow.
Oblige.
Yes.
Lordship permission, Lord. Serial number 44, Lord, I was here. Sorry, Lord. It's called.
What happened?
Dismissal.
Which one?
44.
What happened? It must have been posted for dismissal.
On 18A.
Huh?
August 18.
August 18.
But it is, Lordship,
For
he told that, Lord, it is dismissal.
No. It will never be dismissed first time. It will always be posted for dismissal.
Both of you.
Then once you don't come on that day, then it will be dismissed. First time, no case will be dismissed in this court. Yes, next.
Cell number 53.
I appear for the petitioner, my lord. Sorry. Case of enhancement, my lord.
Why?
My lord, in this case, the trial court, my lord, is rejected.
Only.
Yes, ma'am.
He has no papers, it seems.
Only writ petition copy is there, my
He
lord. I'll
wants
secure all the
papers.
records.
He will, if you serve, he will argue.
Yes, my lord. Date may be fixed, my lord.
Copy of the petition on the council for the respondent, entire set. List the matter on 4th August.
Much obliged, ma'am.
Cell number 54.
Yes, 54.
Appearing for the appellant.
Yes.
My lord, short announcement. Last time, my lord has.
It's coming to 90,72,060.
My lord has calculated it.
19 lakhs? 19 lakhs 68,818. How you make the calculation? 11,000. So 1 minute, let me make the calculation again. So 11,000. 1 minute. 11,000 Future prospects at 40%.
40%, yes, my lords.
Into 40 divided by 100, it comes to 4,400. So 11,000 plus 4,400 comes to 15,400. Then how many are the, how many?
Two persons.
Into 1 divided by 3. Yes, 5,133. If you minus it, it comes to 10,267. 7. 12 into 15. It's coming to 18,48,060.
Yes. Yes.
Then 88,000, 36,000.
Yes.
Then if everything is same, why the calculation is changing? 1 minute. 1 minute. 160 plus same, my calculation is correct. 19 lakhs 72,060. How can it? No, calculator calculating and saying it.
Other heads ಕೊಟ್ಟು.
10,000 I have not granted.
No, I'm saying 10% escalation is given, I believe.
Nothing.
Nothing is.
As it is.
Then, my lords, it is 88,000 means, my lords, 10% escalation is given.
No.
Otherwise, it is, my lords, 40,000 each.
9. Oh, that's what 44.
44, 44.
From long back, I'm following that. Even for now, funeral expenses, this code is granting 36.
Yes.
And this 44. So 44, 88.
Correct.
Not only, I'm granting it from a long time. Huh? 44, 88. 36, not 33. That also hike. So it becomes 19,72,060.
Yes, months. His calculation, my lords, is only in mind. Same calculation.
Yes. So what was not considered by the court?
My lord's calculation is.
No, not here. To dictate the order, you have to tell me what is that not considered. That 40% is not considered.
Once it is considered, what they have done is, my lords, they have taken the income at, my lords, 14,500, which is on the excessive side, my lords. Now, my lords, we are reassessing at 11,000 and doing 1/3, my lords, as deduction. There it is done as 1/2.
No, but
by the
that
tribe.
is appeal.
Yes, my lords.
Why are we doing recalculation?
Because-
If it is the other day, some
Yes.
For arrangement, we will do the recalculation. In his appeal, what is granted by the court?
My lord, tribunal has taken income at rupees 14,500.
No, how much is the amount? By
My
the
lord,
court?
amount granted is, total amount is 19,12,000.
Under the loss of dependency, my lords, 18,27,000 is granted. Here, my lords, after reassessment, 18,48,000 will arrive.
Lord, loss of, my
14,000,
lord,
1 minute, 14,000 is taken as salary.
Yes, my lords.
According to you, 40% future prospects were also added.
It is added, my lord,
And
there
then
also.
in that case, there should be a lot of difference.
Not here, there it is, my lords, deduction is made as 1/2 or 50%.
my lord,
Oh, that's a difference.
my lord, submission is, the finding is given that the accident is of the year 2017.
2070.
In para number 17, they have wrongfully
Considered the-
considered it as year 2020 and taken income as rupees 14,000.
Now you are on
Yes.
the deduction of 50% instead of doing 1/3.
1/3.
And
Income taken is wrong by the tribunal.
that is their contention. What else are your contentions? Only on that point.
Only on that.
50%.
Yes.
But since, my lord, the tribunal on the notion that the accident has taken place in the year
that I will
2020,
consider. Your
consider, my lord, as,
submission,
yes, that, my lord, needs to be-
Agreed with the orders passed in MVC
बताइए
number
सर।
25/2020, dated
And that dated
24/4/2023. The claimant is
Correct.
before this court seeking enhancement of the compensation. Land counsel appearing for the claimant submits to the claim petition has been filed, seeking compensation of an amount of rupees 53,90,000 whereas the tribunal has awarded an amount of rupees 19,12,000. It is submitted that when there are two claimants, court had deducted 50% towards the personal expenses, which is on the higher side. Even under the conventional heads also, the amounts that were granted by the court are not a just and reasonable compensation. Next para. When counsel appearing for the insurance company submits that the accident has taken place in the year 2017, and as per the chart prepared by the legal services authority, as there is no other evidence, the amount should be 11,000, but the court had taken 14,000.
14,500.
500, considering that the accident had taken place in the year 2020.
Yes.
In the year 2020, he submits that no appeal is filed by the insurance company when there is evidence on record and there is a clear, when the finding of the court is not justified, this court can interfere with the same. Land counsel for the petitioner also does not dispute the fact that the accident has taken place in the year 2017 when there is no income. The notional income has to be taken at 11,000. Considering the same, this court is passing the following order. Not following order, hence, having heard the counsels on either side, there is a material on record. In the accident has taken place in the year 2017, the income has to be taken as there is no other evidence as per the chart prepared with the legal services authority. The income has to be taken at 11,000. As the age of the deceased was
38 years.
38 years. Future prospects have to be taken at 40%. It comes to 4,400. Then the income is 15,400. As there are two claimants, the court ought to have deducted 1/3 instead of 50%. It comes to 5,133. Then his contribution to the family would be 10,267 into 12, and the relevant multiplier is 15. And under the head of loss or dependency, it comes to 18,48,060. Then under the conventional heads, towards consortium, 44 into 2, 88,000, and towards funeral expenses, 36,000. Altogether, the claimant is entitled for an amount of rupees 19,72,060. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 19,12,000 to so and so.
Interest.
55,
6%. It will be there in all the orders.
Yes, yes.
55,
Yes.
Respondent.
What's that?
My lord, liability of 2 and 4 are equal. Liability of
Liability
ICICI
marks is fastened 50% each months on both insurers.
The court has fastened the liability on both the insurance companies at 50% each.
Same is retained.
Huh?
Same may be retained.
And 50% each, and both of them are liable to pay the amount. Delay is there.
No delay.
It is there. Is it unknown?
256 days. No, 256 days.
Condition is there, no? This court has condoned the delay by order dated so and so on the condition that he is not entitled for interest. But accordingly, petitioner appellant is not entitled for interest. No condition. 250 days. No, the other date is happened because it is. It will be settled in the Lok Adalat.
Yes.
It is just like that condoned. Anyhow, that we will leave it. Yes. Yes.
Your Lordship, in this matter, represent petitioner, Your Lordship.
No, 1 minute. There are two petitions.
Yes, Your Lordship.
RPFC and
WP.
why RPFC and WP are clubbed together? WP is filed by whom?
Respondent.
Questioning what?
Question.
Yes, what is the amount that is, you're seeking enhancement?
Yes, Your Honor.
What is the amount, where is the impugned order?
Page number 31, Your Lordship.
How much is granted?
6,000 for the first petitioner and 4,000
1,000
for
to the
second
first
petitioner.
petitioner and
4,000 for second petitioner, Your Lordship.
10,000 is granted.
Yes, Your Lordship.
And what is the income of the husband?
1,87,000, Your Lordship.
How much is claimed by you?
50,000, Your Lordship. 1/3.
Please come to the findings.
Your Lordship may kindly see. Page number 30, Your Lordship. Para 16.
15, from 15 you read.
50.
What is the age of the child?
11 years old. Studying
From
is-
how long they are separated?
From 2016, Your Lordship. He's studying 600.
What about the matrimonial relation?
Sorry, Your Lordship.
Any cases are filed? MC?
MC, except this one, no. There is no divorce court present. They have not filed any.
Why she is not staying with the husband?
Because he deserted the petitioner.
Who deserted?
Respondent deserted the petitioner after gave the birth to the child.
Has she filed for restitution?
She has not filed, both parties not filed. Your Lordship. Either divorce petition or restitution of conjugal rights not filed.
Admittedly, the respondent is working as assistant professor in Karnataka Veterinary Animal and Fisheries Science University. He has produced his salary certificate as per the memo dated 19/2/2022, wherein his gross salary is shown as 1,29,781, but home take salary is shown as 14,828. What is OT?
Other deductions with respect to the insurance and the tax.
Can anybody 1,29,000, everything is deducted and you get 14,000? What are those deductions? Where is that salary slip? Page number?
Page number, may kindly see, Your Lordship. They have filed assets and liabilities.
Yes, page number?
Page number, Your Lordship, may kindly see. 13, Your Lordship. It is salary slip of February 2025.
Income tax 50,000.
Income tax 80,000, yes. But every month it is not deducted, Your Lordship.
How can it be? How can that be every month you pay 50,000 as income tax for the salary of 1,50,000?
80 is
How can it be?
only the purpose of avoiding to give maintenance, they have obtained other loans. 80 lakhs obtained loan, Your Lordship. May kindly see page number, Your Lordship. Page number.
What is this NPS?
Page number 7.
What is NPS? Huh?
New pension scheme.
So you're contributing 16,000 for that. You have to, that 50,000 probably, no, 50,000 we need not calculate. Remaining 15,809,160, all this will come to around 25,000. What is that? What is the other thing you're relying on?
He is mentioning one site as purchased by the respondent, but he has not mentioned ancestral property, sir. He has more than 5 acres.
What is, in which class the children are?
6th standard, Your Lordship. At
Standard.
6th.
What did she study? What is her qualification?
PUC, Your Lordship.
PUC.
PUC. But she is not working. She is after. Correspondent. Sorry, correspondence did BA, Your Lordship. After PUC, correspondence she
Why she is not working?
Because after desert, she went to the depression, Your Lordship. She is medication till now. If not take the tablet, she will fall in.
So children, which class, sir?
6th standard.
Both are.
6th standard, Your Lordship.
Only one daughter.
Only one son.
One son, 6th
Yes.
standard.
Yes, Your
What
Lordship.
are his expenses, school expenses?
School per annum it will take, per month it will
Tell
take.
her, ask her.
ಎಷ್ಟಾಗುತ್ತೆ ಫೀಸ್ ಅದೆಲ್ಲ ಆ ಹುಡುಗನಿಗೆ ತಿಂಗಳಿಗೆ 30,000 to
30,000 per annum.
per month, per month, Your Worship. Per school when.
From she's paying.
Sorry, Your Worship.
Where from she's paying with 10,000 maintenance, 30,000 per month school fees.
Per tuition, school fees and food,
I
everything.
understand. What is the source of income I'm asking?
Sometimes she avail loan from these brothers and her parents, Your Worship. And also she has in rent house.
Should be some reasonableness.
Yes, sir.
So 30,000 per month means 3,60,000 per annum is the school fees. Which school is studying?
Siddhganga English medium school, Your Worship. Siddhganga school.
Let her come up with actual figures, we'll see. What is the expenditure for the child?
Maybe around 10 to 20,000.
Not around, let her say, let her file your statement before the court that what are the expenses of the child, what are her actual expenses. Then we will consider.
That's all.
Then comes to the petitioner shall, the petitioner shall file before this court, what are the expenses exact. I'm telling not, I will not grant, I'll completely dismiss the petition, whatever is granted will remain. When I'm asking actual figures, don't exaggerate anything and give the actual figures. The petitioner shall place before this court the actual figures, the expenditure pertaining to her and the child by the next date of hearing. When can you file?
And, meanwhile, may direct the respondent to pay the arrears, sir. From last 2.5 years not paying the arrears, sir. Because it is very difficult to.
By the next date of hearing, learned counsel for the respondent shall file before this court the memo of calculation, what he has paid from the day, as per the order impugned in RPFC number 95 of 2022. Basing on that, further orders will be passed. Both the parties shall file the petition shall file the affidavit, the respondent the calculation memo by 11th of August and shall serve the same on the other side. List this matter, if both are filed, list the matter on 13th. Yes, next.
That's okay.
That's what court will do what is supposed to be done.
కదా ಇವರು GMFC ಬ್ರಾಂಚ್ ಅವ್ರನ್ನ ಒಂಚೂರು ಕರಿ ಅಲ್ಲಿ ಪೋಸ್ಟಲ್ ಸರ್ಡ್ ಅಂತಾರೆ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಐತಿಲ್ಲ ಬಿ ಫೈಲಲ್ಲಿ 25 ಕೇಸ್ ಕೊಡ್ತಾರನ್ನ ಫೋನ್ ಮಾಡ್ಕೊಂಡು ಇದೊಂದು ಕೊಟ್ಬಿಡಿ ಇದೆ ಬ್ರಾಂಚ್ ಕಳಿಸ್ಬಿಡಿ ಪುಟ್ಟಪ್ಪ ಅಂತ ಆಗಿದೆ ಇದು ಕೊಟ್ಬಿಡಿ ಅವನೇ ಬಂತು ಹತ್ಬಿಡಿ ಬಂದಂತ ಆ ಪಕ್ಕದ ಬ್ರಾಂಚ್ ಅವನಿಗೆ ಫೋನ್ ಮಾಡಿದ್ದೆ ನಾನು.
ಹೌದಾ?
ಇನ್ನೇನ್ ಮಾಡೋದು, ಫೋನೇ ಇತ್ತಲ್ಲ ಸದಾ, ಅದೇನು ಫೋನ್ ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು.